led by Mr. Kutaria.
He'll be there sometime in the.
But he's accepted notice. So my lord, can you fix it at 2 p.m. also on any day, my lord? At least it can be taken up, my lord.
You will be there in the court today, or you will not be there?
Who?
You.
I'm here, my lord.
You are here. Mr. Sharma will be here for one of the matters.
My lord. But in this matter,
I don't remember which. Will be there. Probably
tomorrow or day after, anytime, my lord, will kindly fix this matter.
Probably in item 7 he's there.
My lord.
I think so, because that's also an income tax matter.
But my lord, since today is appearing down in the list, probably he'll not be prepared also, so it's not fair on my part.
No, I won't take it up today, but I'll be able to fix it in his presence.
My lord, I'm here only, my lord.
What has happened? Upgradation?
My lord, customs, my lord, came to my office. My lord, 43 lakhs without giving any signal.
You give it, it will take some time for it to be upgraded because there are already a lot of upgraded matters.
May the Lordship.
830. I have come after the appeal order, Lordship. More than 10% I have paid. The issue is that inadvertently there was an error in GSTR 1 and 3B, which was corrected in 9. But the appellate authority has not considered the GSTR 9. The Lordship has passed similar orders. Now the department is, because more than 30 days of the appeal order has passed, now they are forcing for payment further.
Give it, I shall see. It will appear after some time. Matters will be upgraded again.
May the Lordship kindly mention item number 608. I'm praying Lord to upgrade the matter.
Why?
There is an urgency because they have issued the notice for
what
recovery.
Have you come against?
Against the adjudication order.
Why have you not preferred appeal?
The adjudicating authority, without giving any cognizance of the document which I have submitted before him, he has passed the order. They have acknowledged the documents, but they have
Give
not.
It, I shall see, but don't come and mention tomorrow that it is not upgraded.
No.
I'll get finish some matters, then I shall add.
My lord, 2 matters for upgradation. My lord, urgency is that my claim of refund is going to be adjusted against the claim of GST, because I am entitled to stay upon payment of 10% of the amount.
You paid 10%?
No. The matter is pending, my lord.
No, you have not paid 10%?
No.
After 10% only they will not be able to adjust. Then they are rightfully adjusting. If you have preferred appeal, then in that case they would have done that. You have come against adjudication order?
My lord.
Not against the appellate order?
No, my lord. Because there is a violation of natural justice is concerned, my lord.
That way, every the court is being flooded with writ petitions. Appellate authority is sitting in bliss, blissfully enjoying that. You give it. I shall see. Because there are already a lot of matters. If all matters will be in upgraded list, and the normal list will be blank. So please wait for some time.
Grateful.
Item number 212, I'm paying for upgradation. My GST certificate, my registration has been cancelled.
For what? On what ground? On what ground?
There's a demand. There's a demand which is also impure. Somebody else, my lord, I was a victim of fraud. Somebody else, my CA, my lord, logged into my account, made some transactions.
So why don't you prefer appeal against that?
Registered.
Prefer appeal against that. All these issues, how even then registration, revocation of there is a provision for revocation of residence.
One fine day, I'm told that your
difficulty may not be upgraded now.
You will be permitted to mention a matter, this is a matter where it's a case of change of opinion.
And matters which I'm accepting, don't feel that it will immediately be upgraded. I shall see the file and then I shall upgrade it.
It's a case of change of opinion which we are alleging. The assessment order was passed initially, and again they are reopening the assessment on a different ground, where this is our case. This is a matter of 2025. We have mentioned it earlier, if it can be upgraded. It's appearing as item 430.
Give it. I'll take the slips. I shall go through the slips. If I find there is urgency, I'll upgrade. Otherwise, you'll have to wait. Don't think that I have taken the slip, therefore it is going to appear.
Item 430.
Inclusion, please give. Inclusion, don't mention. Don't mention for inclusion. Please give.
My lord, may I be permitted to mention one matter? The petitioner is not getting promotion in grade 3 in the finance department, but the other members are getting the promotion. Direction was given to file affidavit in reply. My lord, this is a group 6 hearing matter.
Which year?
My lord, 2019. Inclusion.
Inclusion, please give.
Yes.
My lord, may I have my lord's kind leave to mention a matter? My lord, the GST registration of the petitioner is cancelled for not filing of returns. My lord. That is a
तो
petition.
दिए upgraded it. Give it, give it. That will be upgraded because non-filing of return is covered issue, not problem. Yes.
Your Lordship may be permitted to mention for upgradation of item number 724 of Lordship's list. My lord, appeal file pre-deposit has been, my lord, also been deposited. My lord, during for the condonation of delay, that matter has been.
Donation, there is a
yes.
problem. There is a problem.
Yes, my lord.
Matters have been fixed on 17th.
Lordship, may this.
You can give it, but wait till 17th and then give.
Okay.
Yes, chalo, call it.
Oh, I would file a reply.
Your Lordship, the interim order is expiring at the end of February, Your Lordship, and we have filed the affidavit in reply.
Affidavit in opposition reply finished. What is this matter about?
6(2)(b). For the same issue, Central was already in seizure of the matter.
If it can be taken up, then isn't it? Today can it be done? No.
No,
No, if it is that only, then we can finish it off unnecessarily. Why do we keep it?
Can you next week, can you keep it under the hearing on the next Wednesday? We
Next
can,
Wednesday. Next Wednesday means day after tomorrow.
not tomorrow, on the Wednesday week.
Well, Tuesday, not
Because
Wednesday.
Mr.
Tuesday,
Ma-
20,
Ma-
No, I
9.
take Wednesday.
9th
Hearing is on Wednesdays.
Oh, hearing.
Mr.
Second.
Kanodia will take at least half an hour to 45 minutes.
No, Lordship. This is a
Normal
small
matter.
matter.
Should not.
Should not, Lordship. I will not, Lordship.
We should
Going by
injunct
his
him.
reputation, man, 45 minutes I always.
Because only thing we have to see whether proceedings had been initiated or not. But
Lordship.
now it's settled armor.
Summons, Malad, yes, Mr.
Armor.
And it's settled, and in fact, Lordship, for the same SSC, already another it is there, wherein we have got a stay on merits, which was issued by DGGI. So here we are challenged when DGGI has issued notice for 5 years, how can state pick up 1 year out of that? For the entire composite 5 year, DGGI has already issued a show cause which is pending before this court.
Choose one of the principle is same subject matter.
Same subject matter. It is, both the notices will show that. Rule 96.
Lawyer doesn't make.
আরে ওটা তো ব্যাক কি হবে, ওটা তো আপনারা কিছু ফাইলই করছেন না না আইটেম নাম্বার তো দিতে হবে আপনার লিস্টেই নেই ওটা তো 5 হাইকোর্ট ডিসাইড করে দিয়েছে দিদি
লিখে নিন This matter is appearing under the heading extension of interim order
the end of February.
our below affidavit in opposition.
I have received it yesterday, my lord, the opposition.
So, my lord,
What is the matter about?
Your lordship, this is matter under section 74, where the allegation is the ITC which has been claimed by the petitioner is ineligible on the grounds that the seller's registration has been cancelled retrospectively.
Where is the interim order? There was an interim order.
Your lordship, the last on 15th December, your lordship.
15 December I have, but I don't.
Your lordship, before that, there was order dated 14th October.
Where is that?
during the vacation,
During vacation,
certain interim orders were passed.
14th October.
Right, sir?
What is the interim? State. State till 15 December.
Then on 15, my lord had passed.
Where is your affidavit in opposition?
Take it there. Well, this is my affidavit in opposition.
Affidavit in opposition. তার উপরে ওই লাইনটা লিখে দেবে। But Mr. Dhuria, what was the direction and what is the report?
Your Lordship, on the last occasion.
Because not on the last occasion, Your Lordship, they said not they don't have any document except the first document. Your Lordship said not in absence of document whether refund can be issued.
No, that was not the direction. Are you disputing the appellate tribunal's order? What is the?
But the appellate tribunal's order is not being according to Lordship will kindly have a look paragraph number 7. What they are saying, from in the ITBA portal is saying there is no refund due. Understood.
Will not be.
So, my lord, what I'm humbly submitting, my lord, subject to Lordship will not take it my word, my lord. Lordship will kindly Lordship order. My lord, refund may be issued, my lord, subject to one condition. But if it was found that earlier the refund was given to them, in that case, my lord, they will return or they will file a bank.
The writ court also will not go into so many things.
Yes.
I'll ask somebody to decide into it, looking into the because you will have access of the records.
Yes.
The petitioner will produce whatever he has, and on the basis of that,
Yes,
he
yes,
will
Your
have to
Lordship
take a
can-
decision.
Your Lordship,
Because unnecessarily, I will call
Yes, yes.
for affidavits. It will remain pending. I
Lordship,
cannot
I was-
decide that.
Let them produce whatever document they have.
And
not-
I cannot directly direct them to refund whatever is there without them verifying what the
Your
records
Lordship,
are.
the only thing I had submitted that Your Lordship will kindly see what are the documents they're asking for. That copy of the ITR filed by the assessee, which is, this is a Japanese company, Your Lordship. They are done business.
Whatever company it will be,
Yes.
madam, for 30
But they
years, they will not keep the records because if they start keeping records of every SSC for
Yes.
30 years,
Your Lordship,
they
here
will
on-
have to vanish.
But in my humble submission, Your Lordship, that this
Every
is an
year, an
undisputed.
ITR of this volume is filed by companies.
Well, I am
Now, if
not
they
the-
start keeping those records, it will be difficult.
Your Lordship,
You
at
also have
our
the-
end also.
you know that there is a refund payable to you. Why will you not maintain your records?
Your
They are
Lordship,
not absolutely
it
wrong.
is,
in
it is
demanding that.
it is not in Your Lordship, that is an admitted fact. Then they are asking for.
No, it is not
certified-
admitted. It is not admitted. Now
May I-
they are in doubt as to whether you have been paid also or not. Now, therefore, you have to show your records. Why don't you produce the records? If nobody has the records, then in that case the court is also helpless. How will I help you if you are yourself not helping
Your
yourself?
Lordship, we had written to them. We have been writing to them since, Your Lordship, they have kept it pending. They have not replied. It is only after we have come to court now that our
Very well.
application.
Now they have replied, and the reply does not show that it has been made.
And Your
with
Lordship,
any,
the
ulterior motive, or the reply is a nonsensical reply. The reply makes sense because they cannot be accepted to keep. Expected to keep records as old as 30 years, 50 years for every SSC because you are not the only SSC. There are so many across.
So then Your
SSCs across
Lordship,
the
then
country.
as Your Lordship, as this the certified copy of the assessment order, their order, which was revised, and they have revised it.
What they have revised.
The originally I was allowed. Thereafter they have revised it, and then I was not denied the.
Where? Which page?
Your Lordship, I am referring to the documents of the report, page 3. Your Lordship will kindly see what documents they are asking for. I'm asking for the third document. It is their document which they have further revised.
This document is also part of the record, madam. If they don't have the record of 30 years with them, they are not supposed to keep 30 years records.
Your
You are
Lordship,
supposed
then,
rather to have it because you have a claim. It will not be expected of the department to have this.
no, I
It will be-
understand, but
it
Your
will be
Lordship, here,
inhuman on the part of the department to maintain so many records across years for so many assessees. Impossible.
Your Lordship,
It's
I
absolutely
understand, but this
impossible.
is a Japanese company. They have done business over here.
Whether it is
So, Your
Japanese or
Lordship, then
Indian is
that
immaterial. It's an assessee.
then they can consider, or Your Lordship, in the event what my learned friend is suggesting, that the refund may be issued in case we have
I
earlier
cannot
got your.
grant an order of refund merely because he says. I have to apply my own mind. According to me, this case at all should be decided by a high up in the income tax, I mean the revenue department. I'll direct him to take a decision on whatever available records and whatever you can produce before the authorities, because it will be an order without basis if I ask them to go and start hunting for record 30 years old. Impossible. It's impossible.
That we are.
And in any case, 10 to 12 years is something which people can be said to maintain. 30 years old record, you are a person who is supposed to have your record because you have a claim on the basis of that. You don't have it. Somebody who wants to give it, he will wash his hands off at the
And
very
also,
first
Your
instance.
Lordship, as Your Lordship was saying that this is admitted, the tribunal gave us the relief.
Very well.
Please
Tribunal may
withdraw.
have given the relief, but their claim is whether in the meantime they have paid it off to you is also not clear. Tribunal's order is not the be all and end all.
No,
There is
after that,
there is, yes, after that you say you have not been paid.
yes.
They are in doubt whether now, if you say that you have not been paid,
So
show
let
them
Lordship make this page 47, Your Lordship, be written to the authority.
whether the order was given effect to or not, because I said if it is not in dispute. Now they are not in clear terms on that. There is no use calling for further affidavits and delaying it any further, because that's not going
Yes,
to
it's
inure
not
to
going to
anybody's
spoil.
benefit.
Good. Lordship will be written to them, page 47, Your Lordship. There are representation. They have not replied.
Rather, that will be better. I ask them to consider it and see whether you can be paid on the basis of whatever records you have.
But they are saying they do not have, and they are not sure whether they've already issued the refund or not. They are saying that we should produce also the records. Your Lordship, the reference which they had filed before the Honorable Division Bench, that will contain also the original. It was their reference, which they have subsequently withdrawn.
Because of monetary limit.
Yes, whatever. But
what happened to that reference?
That Your Lordship,
It was
kindly
withdrawn
that order.
because of
It is monetary limit.
monetary
It
limit.
is annexed, Your Lordship,
It,
page
it
46.
was dismissed when?
Page 46, in
Page 46.
2019, 31st
19.
July.
Page 46.
46 is the order of the Honorable Division Bench.
Reference was of 2001.
Yes, Your Lordship. At that time, while filing the original records, Lordship, the only impediment is Japanese company, they've done business and this is how it is stuck.
Difficult.
This is the division
Let
bench.
me also think over it. I am keeping it 1 or 2 days later. I'll also chew over it if I can think of something better, or I will send it back wherever it has to go.
Yes, I'm deeply.
Because there is no use calling for any further action. That is not going to solve the problem.
Yes.
We want a solution.
Yes.
Now, solution,
The
I don't
interest of-
see it coming as of now. I don't see the solution coming. Passing a direction which will be seamless in nature is also not going to solve the problem. It will only prolong the issue. Litigations will, multiply. Nothing else is going to happen. Let us see.
Well, Lordship, if something can be worked on, as you were suggesting, that in case we have.
No, but that is not.
No, I'm not.
Report in the
Because they
form
are
of
saying
affidavit.
nothing about you, nothing else you.
The report in the form of affidavit filed
Happened in this case, my lord. That refund there is the judgment passed by in case of ocean freight. My lord has recently passed a judgment in case of sunrise tin plate, my lord. That what happened in this case, my lord, we file an application for refund on the basis of the order passed by the Honorable Supreme Court, and subsequently the adjudicating authority allowed our application for refund.
Who is appearing for the other side?
It's Manushi Mukherjee, my lord. It was Manushi Mukherjee and Bijitesh Mukherjee is the answering respondent. State is only a party.
Thank you.
It is not required to be made party.
Can you get her? Then I'll pass it
Yes,
over.
pass.
Pass over.
Right.
Pass over. Yes.
Mr. 6 was that matter wherein the appellate authorities advance ruling classification order was challenged because both the authorities has differed. And then we had come before the writ court. And now in the meantime, in December 25, on a similar type of classification, a new bench of AAR has ruled as per what we had desired in our application. So Lordship had directed my learned friend to take instructions.
No, it's actually absolutely different. Man, Jack Oliver, well, what I've understood this, man, the difference is care and cure. If it is for care, it has to be a cosmetic. If it is for curing something, then it has to be a medicated. Now, man, Jack Oliver says it glows the skin, like what happens to Mr. Sankit if he uses this. It glows the skin. It is not for curing.
Before my learned friend starts.
That is the case.
No, I am not on that, Lordship.
I am today equipped with a Supreme Court judgment where 9 materials was considered like it's a dandruff. On a serious note.
He has used it or not?
But he's such a glowing skin all the time. So,
This is pro bono because he has used it.
He has a stake. I believe he has a stake in Jack Oliver. So many matters he does for Jack Oliver. My question is, like I give it, if it is for dandruff, then it is for cure. Whether, and the second test will be, my lord, whether it is being prescribed by any doctor or not. But there are different views on these issues in the Supreme Court. There are different views. Prescribed. Jack Oliver is never prescribed by any doctor. Ingredients is immaterial.
No.
Ingredient is immaterial.
No, he was on a question.
Lordship.
If I recall that if the authorities have differed.
If he has the authority, read court has to. Today the
Decide.
question is.
No, Lordship, what was my point? Just
This has to be on epidemic.
Just 2 minutes. Just 2 minutes, Lordship.
Interim order.
There is no interim.
But there is no scope of interim order. This has to be on epidemic.
Lordship, my point.
Just one second. This has to be on epidemic. Just for my learned benefit also.
What was the point?
Lordship, the point is, Lordship, that the medicament, if it is from the authoritative textbooks of of the authoritative Ayurvedic Pharmacopoeia of India, if the ingredients are from that, then it had to be classified as medicament. And there are n number of Supreme Court judgments on this. In my case, Lordship, I have been manufacturing this since last 25 years. Now, up to excise regime, it was always classified as medicament. There was no dispute ever. It is not a new product that I am manufacturing today. Under the GST regime, I continued it as a medicament only. But because of a new agreement that we came up with a job worker, we came before the Advanced Ruling Authority, and the Advanced Ruling single bench, the Advanced Ruling Authority stated it to be a cosmetic. We appealed before the AAR. And our only point of contention was that what are the ingredients? The ingredients are as per the authoritative textbooks of Ayurvedic Pharmacopoeia of India. Now, Lordship, this is what the latest AAR judgment which I referred on the last occasion. Kindly takes that judgment for once. The head note.
Before my lord, please the judgment. Facts has to be.
That is the facts.
No. My lord would kindly come to page 9. Today there is a change in the definition. What is cosmetic? Page 9, ground 5. He has quoted, my lord. This is very important. Kindly see. Beauty or makeup preparation and preparation for the care of the skin. For the care of the skin, my lord. Kindly see. other including sunscreen, so and so. This is, my lord, cosmetics, which is at 18%. Now, my lord, kindly consider the next page, 10. Yes. Kindly see the next page. Now, how it is described. For soft, smooth, glowing, and healthy skin. But it is absolutely a case of care. Kindly see. Middle portion for soft, smooth, glowing. This is his description. Now, my lord, kindly see the left-hand corner. An effective herbal body oil for soft, smooth, glowing skin. This falls with deepest respect within the beauty or makeup preparation. This adds to the glamour, my lord, if I can call it that way. That's why I said, man, this matter requires an
Same page, the column which my learned friend skipped, the third column in that image, Ayurvedic proprietary medicine, and it is by the Drug Controller of India. We have the Ayurvedic certificates from the Ministry of Ayush that it is an Ayurvedic proprietary medicine. We have a drug certificate from the Ministry of Ayush certifying our product.
What is the difference? What is the order that is now under challenge?
Not now under the AAA deferred. The member central stated it to be Ayurvedic. Seeing the contents that okay, it is from the authoritative textbook of the Pharmacopoeia of India, and under Ministry of Ayush you are authorized to do it. So we did not go into the common parlance test because Supreme Court has now ruled common parlance test is not applicable for classification matters since excise regime now. Now the member central held that no, yes, you fall under Ayurvedic and you have been correctly classifying under 12%.
And the other members?
The member states stated no, and they differed. Now, as what I read, Lordship, on the last occasion, section 97, 99, if two members of the AAA differs, the double A ruling also goes. Now, problem is, Lordships, I am being faced with a demand up to 40 crores for this issue. And it's a recurring demand, Lordship, every year. Now, from 24 onwards, I have given a letter to the department. I am making payment 6% additional from my pocket because I cannot collect it from customers. I have not increased my price. I have written a letter to my proper officer that because of this issue, we are paying this every month under separately through a letter so that whenever this issue is decided, I can claim a refund. Because if I charge it from customer rate, I increase the MRP, unjust enrichment will happen. I cannot get the refund.
So this
no, not this judgment which I referred on the last occasion. Lord, you kindly take judge that. Why I say this AAA ruling is now clarifying the position. I had given this Lordship, the first page, the head note. I'll just take the head note. I just head note, Lordship, it is from the relevant. I can take from the relevant order, Lordship. No problem. Lordship, may kindly come to page number, internal page 4. The page numbers are given in top right side bottom, Lordships. Page number 4. Discussion, observation, and finding of the authority.
Yes.
Lordship, the applicant has raised the following two questions. Number 1, what is the HSN code and rate of tax of medicament manufactured exclusively in accordance with the formula described in the authority books specified in the first schedule to the Drug and Cosmetic Act or Homeopathic Pharmacopoeia of India or USA or UK or Germany? I am only up to Homeopathic Pharmacopoeia of India only. My product is within that. And what is the HSN code and rate of medical manufacture exclusively in accordance with the formally described in the authoritative book specified in the first schedule to the Drugs and Cosmetic Act or the Pharmacopoeia of India? This is exactly my question. Now, Lordship kindly takes the ruling. Para 4.4. The AAR gives down the schedule because there was an amendment in the schedule, Lordship, from September 22 to 2025. The rate has been decreased from 12 to 5. Up to 22 December, it was 12%. Lordship, 4.6, page number 7. We should first define the term medicament. The GST Act nowhere defines the term. The word medicament is defined from the Latin term medicamentum, meaning drug, remedy, or medicine. According to this dictionary, medicament refers to substance used in therapy. According to vocabulary.com, medicament is something that treats or prevents or alleviates the symptom of disease. The Collins Dictionary defines medicament as medicine or remedy in a specified formulation. In the pharmacy context, a medicament is a chemical substance or formulated preparation used in prevention, diagnosis, treatment, or relief of disease and symptoms. It is broad term encompassing various forms such as tablet, capsules, liquids, creams, and it is used to describe anything that acts as a medicine. The applicant manufactures the following. The lists are given. Going by the definition of the medicament, all the above noticings will come under medicament describing server. As per understanding of the applicant, the medicament have been divided into two categories for the purpose of charging GST. The first category of medicament, including those used in Ayurvedic, Unani, Siddha, homeopathic or biochemic systems, consist of single constituents and manufactured exclusively in accordance with the formally described in the authority book specified in the first schedule to the Drug and Cosmetic Act or Homeopathic Pharmacopoeia of India. The second category of medicament consists two or more constituents and manufactured exclusively in existence accordance with the formula described in the authority textbooks. Now, Lordships, it has been extracted. Now, kindly comes to Lordships, para 4.9. It is evident from para 4.8 that medicament manufactured by the applicant that consists of two or more constituents mixed together for therapeutic or prophylactic use and that is not put up in measured doses or in forms of packaging for retail sale will be covered under tariff this, and accordingly it will come under entry number 233 as amended. The rest of the medicament manufactured, whether consisting of mixed or unmixed product, will be covered under tariff, and accordingly it will come under entry 234 as amended. It will include medicament manufactured by the applicant exclusively in accordance with the formula described in Homeopathic Pharmacopoeia of India or United States of America or United Kingdom or the German Pharmacopoeia, as the case may be, when sold under name as specified in the Pharmacopoeia. Now, Lordships, what my learned friend was showing, page number 10, right, that image. Ayurvedic proprietary medicine. I am authorized by Ministry of Ayush, Government of India, and all my ingredients, Lordship, I kindly see the ingredients: Manjita, Arjuna, Kapoor, Durardika, this oil, and Ashish oil, olive oil. All these are from the authoritative textbooks of Pharmacopoeia of India, and I have been manufacturing this last 20 years. So the constituent test, what I am manufacturing, is based on what is the constituent test. Supreme Court, n number of judgments, it is on record in my my petition also, wherein Supreme Court has held the common parlance test, the customer use. Earlier, Lordship, when excise regime came into picture, the common parlance test was the main test. What is being seen by a common person, it would be taxed accordingly. But the law has evolved since 1944. Today we are in 2026, and there are Supreme Court judgment which says no, common parlance test you need not go. First is the ingredient test. If the ingredient test is satisfied, then your product, even though maybe can be used without any prescription or any dosage, because it is sold under normal stores. You need not require a doctor prescription for every medicament. I have judgments to that extent also, which are part of my writ petition also. So now, because my point was, because the authority, the double layer itself, has now stated, okay, if you are manufacturing something as per the authoritative textbooks, Pharmacopoeia of India, you will be classified as medicament. That is my only case.
Yes, Mr.
And that proportion also.
But factually, they are absolutely wrong. My lord, would find page 3, my lord. What was the appellant submission?
Page 3 of writ petition.
No, my lord, page 3 of this order, which my learned friend is relying on.
Page 3.
The applicant is manufacturing medicaments consisting single constituents exclusively in accordance with the formula described in the authority book so and so. So medicaments, when they proceed with they are producing medicaments. That is the first and foremost. I'll have to show, my lord, what is medicaments, what is the distinction the Supreme Court has drawn between the term medicaments and so. Now, my lord, would kindly come to page 4. 2. There were specific percentages given assigned to that particular medicine. My lord, page 4 onwards, my lord would find different groups A, B, C, D. Then these medicines are available in 5G. But this is considered. That's why my lord would find there is no argument on behalf of the revenue. Page 4, there is no argument on behalf of the revenue. Can you see? The concerned officer from the revenue has not expressed any view. The premise was not any adversarial litigation with deepest respect. The premise was what it will constitute as. There was no advance. Now,
So his only contention, as far as I have understood, is that if it is in accordance with the medical check.
Well,
then in
uh,
that case,
with-
it is a medical.
Well, that there are
That is the simple,
well, that is then my lord, may I just rely upon one judgment, my lord allows me. Sorry, extra copy আছে, বুঝে গেছে। This is Puma Ayurvedic herbal.
Not to product है, not product classification,
हाँ, हाँ।
दो को medicament बोला, सबसे कैसे
तुम्हारे फेवर में
नहीं, हमको पता है, पता ही नहीं क्यों। अरे मेरा में तो 15 किलो। Thank you.
my lord kindly see the appellant claim first paragraph onward.
Yeah, which one?
My lord, one judgment, paragraph 1, my lord, kindly see, these were the 9 products that was in question. That was under scrutiny for the Honorable Supreme Court.
Yeah.
The appellants claim to be a manufacturer of Ayurvedic products which are intended to cure, my lord, certain ailments of the human body. A question has arisen as to whether the product manufactured by the appellant fall within the category of medicaments or cosmetics. Answer to this question determine as to whether the goods are classifiable under the Central Excise Tariff Act as cosmetics under Chapter 33 or as medicaments under Chapter 30. As cosmetic, the rate of excise duty is quite high, while as medicament, the product attracts nil duty. The following products manufactured by the appellants are under consideration. My lord, kindly consider first neem facial pack. It was held to be medicament. Anti-pimple herbal powder. It was held to be medicament. And last paragraph, my lord would find all this, what I am saying, my lord would find from the last paragraph 28. 1, 2, 3, 4, 7, 9, 10, and 11.
ये देखिए ना,
Around.
ये देखिए 12 इसके बच्चे को नहीं करता, 12 अरे वाह।
My lord would find what has been found to be pimples, bald headed, where there is some kind of a disease, my lord, which is a known phenomenon. Just like an oil, my lord, simplicity an oil. Now, my lord, kindly consider from paragraph 18 onward. Yes, after relying on all the more or less all the judgments on this issue, paragraph 18 onwards. May I place it, my lord, subject to one?
I will also play para 11.
Absolutely.
So two tests are to be satisfied. One is whether it's there in the authoritative textbook, whether it is homeopathy or Ayurveda, and the second is whether it is used for curing an ailment or it is used only for improvement of appearance. If the improvement of appearance is a consequence of an ailment being cured, then also it will.
Like a bald head, like a bald head. That's what
That was the example given.
given. Bald head. Kindly come to paragraph 18
So
on.
if these two tests are satisfied, it will be a medicament. If these two tests or any one of them is not satisfied,
Another aspect has to be considered.
This is
Now the heading has to be considered. Now, paragraph 9, that's why round 9 is important. If that round 9 was not in subject to correction, was not in existence, that particular heading. Well, I believe this has undergone change. I believe
round 9 of
page 10 which I had shown, page 10, page 9, beauty or makeup preparation. This is under cosmetics. And preparation for the care of the skin, including sunscreen and sustain preparation. So, if today,
no, but care of the skin other than medicament.
other than medicaments,
If it is a
including
medicament and it is
sunscreen,
leading to a care, then it falls under that example of the honorable where
including sunscreen or suntan preparation, manicure or pedicure. My lord, now kindly come to paragraph 18 onwards of this judgment which I have handed over.
Yes.
From the above judgment, it follows the law is settled on the applicability of the twin test for determination of classification of products. We have already found the twin test is satisfied in the present case regarding most of the items under consideration. The word medicament is not defined anywhere, while the word cosmetic is defined in the Drugs and Cosmetics Act 1940 as under. A cosmetic means any article intended
I
to
have read. I just know those.
20 my lord has read. Paragraph
Yes, I have read almost the entirety of it. You can place the relevant one. I have read the judgment.
But para 11 and 12, exactly similar product of mine. In CT Sharma,
that is not. That's why I first said there has to be readings has to be. This has to be on affidavit because with the product.
How fast can you file the affidavit?
Within 3 weeks without any extension. Because after 2 weeks I come up, I'll ask for extension. With 3 weeks, I'll come up because this will require some affidavit.
Very good. File your affidavit. Heard Mr. Kanodia Learned Advocate appearing for the petition. Next. Yes, Mr. Sharma. Mr. Bagadia was after you. I'm not giving it. That is message. PTSD. I'm representing Union of India. I'm later Mr. Kundindia. I don't know whether I am challenging the virus, so they are the main answering respondents. Commissioner will also be there. Yes, he is also a party. Board is also a part. The main virus issues involved that the union has to answer. Commissioner, how will the commissioner answer the virus point? Not aware whether Attorney General also has to be served. I have served everyone. Attorney General has been served. Yes. Attorney General. Yes. Advocate General, Attorney General. I'll bring the affidavit of service, my lord. Keep it, my lord. I on the board of PM. Who is appearing for SPGSK authorities? Any idea? So that we have also not been able to ascertain. We are trying to ascertain that, but usually Mr. Banerjee, they appear. Usually, my lord. I'll once again inquire of them if they appear. I'll inquire. If they are there, we'll have it. We can have it at a consensus on any date. But the main answering respondent is the union because if the virus is involved. No, CGST. But obviously, because union is an umbrella. So, the authority concerned will have the right. The virus point, my lord. It's all under ministry, no? So, yes, but the union has issued the notification that we are challenging the rules have been promulgated by the union. Well, has to be by the ministry. But what I was my lord will kindly fix the matter. If they come and ask for time, then again my lord will kindly fix. Because otherwise they will not come. Fixing a matter after urgent is Mr. Bagadia, it will have a cascading effect. Everybody would like to have it. That is why I'm not doing it. If all of them are there, I can take it out of turn. But if one of them are there, my lord, it becomes difficult for the court, and to refuse a prayer later on will become embarrassing. It's not. That is why I'm following. Because I have. Let us see for some more days. Maybe I'll reach. Maybe. Well, takes if all of them are there, I'll take it. Yes, this matter. Yes, sir. But when this matter, if I may just briefly recapitulate. I remember Mr. Sharma. My lord had taken it. I haven't taken it. Considering what is my experience with my lord in the Gaurav Enterprises, my lord has expressed that all the judicial presidents that should be stopped. Here, my lord, one point I have to that OM is for the authorities. In case of when any application for staying made is taken out, it is not that automatically it will be applied in all and every case. Without application, it cannot be done. It cannot be. Because that is that OM, that is in fact not notification or circular. That is OM, office memorandum only. So, but Mr. Sharma, just for to get the best out of you also, if you see section 220, that is the mother provision. Mother. Section 220, subsection 6. Mother. So, does that speak of any application? Yes, madam. That also application are required to be taken. It does not speak of any application being made. Now, suppose this application thing is only brought in by way of the OM by in order to guide the discretion that the assessing officer is exercising. The moment he files an appeal, if he does not file an appeal, he is an assessee in default. He has not filed the appeal. So there is no dispute about the tax. Tax demanded is not in dispute. If he files the appeal, he disputes the demand. He's not accepting it, he's disputing the demand. If he is disputing the demand, naturally he won't pay. So he will not be treated as an assessee in default. That is the immediate inference that can be drawn. Now that inference has been fixed by the legislature, saying that no, here we give an elbow room to the assessing officer. He will have a discretion to exercise. He may not. There are circumstances in which he may. There are circumstances in. So will the assessing officer's imagination run amok? Whoever he feels he has a nice face, I'll not treat him as in default. He will not do that. Therefore, there is an OM. This is how you will be guided. Now the OM says that if an application is made, you will do it at 20%. You can go beyond that also, but there are certain conditions if you want to go beyond.
Even they can reduce, suppose lesser amount.
Suppose there is no application made. Then can we read the OM to mean that merely because he was willing to pay, he will pay only 20%. Somebody is unwilling and you have started recovering from him, therefore you are entitled to recover everything of it. Is that the purport of the OM, or the purport of the OM is to guide the assessing officer to a certain extent? That is where we are at loggerhead.
Yes, sir.
That is the point of debate.
Yes, I'm also concerned with that.
That is the point of debate.
Here, my lord, when this benefit is given to the assessor, if a room is given to the assessor, for that assessor has to avail that benefit, so he has to come forward. It is not for the assessing officer to give that benefit.
No, then in that case, the assessees are of two different classes. You are treating a class of the assessees. Those who make application will be treated differently from those who do not make an application.
If my lord assessing here, the conduct is has to be seen, my lord. They are here assessing 5 appeals, never 5 application for stay. It is not that this OM is not in the knowledge of the assessee.
Yes.
It is in the knowledge of the assessee. He could have easily presented an application.
OM is attached.
Yes, sir. It is attached. It is at page 338.
Very well.
While this is basically guidelines given. There are certain problems.
Here also, Mr. Sharma, there is no requirement of an application, is what I found.
The essence is that it is on the prayer of the assessee. If it deposits,
Where is that?
the essence of the my lord, on the deposit of
Said anywhere.
no, it is not said, my lord. On payment of 15% of the disputed demand. So, my lord, it has to be deposited by the assessee.
And in the paragraph 4, my lord, in order to streamline the process of grant of stay. So, my lord, it is not the assessing officer will himself grant stay. And this percentage, my lord, has been made a precondition. Here, my lord, what we have seen, my lord.
Mr. Bhunjalwala, can you please give me a one-page index of these papers, because it's so bulky that the OM gets lost at times.
My lord, may I have?
I will.
OM, I have it. I have.
I'll
The
prepare
relevant
an-
pages, it is 245 intimation, you
My lord.
reply to that, or because
I'll prepare my lord a brief.
because at times the index is also.
My lord, actually,
You have
what
an
happened?
index.
Several documents have been annexed in one annexure.
That
So
is-
that
that is-
creates the
that is what
difficulty.
is-
And I had told my learned friend also regarding this. Please don't do this next time.
Actually, my so happens that my actually the bulk comes on account of your lordship.
If you could just segregate, because if the index was proper, I would not have asked you.
But I will.
Just the index, nothing.
I will.
That will help me in navigating through the bunch of documents that is there.
My lord, may I indicate one more thing? My
Yes,
lord?
yes, fine.
My lord had written in the order regarding page 319 for refund.
Yes.
If that assessment has paid for refund also. My lord, can you see the prayer portion of page 319?
390.
319.
319.
19.
319.
Yes, my lord.
319.
Below this subparagraph C, in light of our stated facts,
After adjustment of demand of assessment to 2220.
2220.
Mr.
And
Bhunjalwala, if you have agreed for the adjustment of 2220.
But 2023 is different. That's 5,000 rupees.
And my lord, that
That is okay. That I'm not agreed. I'm not challenging. That's not a subject matter of challenge.
and thereafter, my lord, there's another.
What is the year involved here?
But this is my lord assessment year 2017-18. The year where the assessment has been made and additions have been made.
So 2223 is no.
I'm not disputing
Doesn't have agreement.
the adjustment.
2223 is agreement.
And the entire paragraph 3 might is to be
And
done.
my lord, 334, in 334, they only prayed for stay of further adjustment. In lieu of that 43%, which have already been adjusted.
And what is your explanation, Mr. Bhunjalwala, to this page 334 prayer?
But we had but if my lord may recollect, in the previous order, this point was raised by my learned friend. I mean, at all times when I submitted that I had filed two representations at the same time. One was that you give me the entire excess, and the second is stay. So my lord, what my lord is looking at is the second application, which is recorded in my lord's first order.
And where is the first application?
That is at page 319 for this assessment here. My learned friend is referring to adjustment for the assessment year 24-25. My lord, the first one is at page 318, my lord, the first response. And then, my lord, the second response starts from page 323, wherein my learned friend is showing paragraph page 354. My lord, may kindly take page 318, paragraph 3 at page 319. Same date, your lordship.
Page 318.
At page 319 and paragraph 3. In this regard, the company would like to take this opportunity and summarize its detailed justification by way of following 3 points, basis which it has humbly prayed that no undue adjustments can be made in the instant case of the outset. This was brought to your kind attention that out of the total influence demand of 10.82 crores for assessment of 17 meeting, a lump sum of 5.15 crores has already been adjusted. This is second case. Already been adjusted, which is an excess statutory limit of 20% under the office memorandum dated 31 July 2017.
And now they have adjusted how much?
But actually, my lord, if I may, just briefly recapitulate the fact for my lord's convenience.
Just this. What percent?
My lord, now today, my lord, we are looking at more than 95, 98, 99%. After this adjustment, because after this adjustment, earlier, my lord, it was 43% by way of 143.1. Second, in fact, without 245 recourse, they adjusted 40 odd percent. In fact, my lord, if I may just briefly just explain, my lord, that earlier, my lord, they collected 100% of the demand without taking recourse to 245. Then, my lord, they revised my demand to 10.82 crores from 4.7 crores. Thereafter, my lord, my adjusted amount became 43%. Then department issued a 245 notice where they wanted to make further adjustments. They adjusted some 50 odd lakhs more, because of which it became the figure of 5.15 crores. Thereafter, my lord, they adjusted 5 or 6 more crores, my lord, and they came to 99 or 98 odd percent. And my lord, this is my lord, and my lord, even after that, they made adjustments after filing the writ petition, my lord. Now, this is the conduct. And my lord, I have been asked.
Anyway, when do I keep it? You give me the index. Week any day.
17th or 19th, if my lord.
Very well. 19th. I don't know it.
Any day.
Heard Mr. Sharma, learned advocate appearing for the respondent revenue authority, and Mr. Mangalwala, learned advocate appearing for the petitioner.
Because this is that matter, my lord, where they have prayed for VC, my lord, and button was not pressed, and
Why don't you? There are so many judgments of different.
yes, I have seen, my lord. Your lordship has to, my lord.
And
But it should be court orderable. Yes,
yes, I'm sending it.
yes,
back
yes, yes,
to get
yes.
a hearing and decide it.
Yes. Because
When was the assessment order passed?
my lord, 28th of March, 2020.
And they have come within time.
Within time, April. Yes.
Setting it aside.
Lordship, and there is a penalty order as well.
Next matter.
Item number 24.
That will be consequential.
Yes.
This writ petition has been filed, assailing an order dated, an assessment order dated. Where is that?
Page number
Now, Lord, I have a talk to the Lord, judicial assessing officer, Lord. Now, Lord, I cannot deny that the contention of the assess is correct. It cannot be bad debt, cannot be added, Lord, in the turnover. But problem is that Lord, the CPC has done this. Lord, till date, Lord, we have no Lord, information from the CPC. But your Lordship may Lord, send back the matter before the CPC for taking fresh decision. But that is my submission because I cannot stand because the law is not that Lord, back that can be added. But I cannot.
Well, he was supposed my lord will pass message because he has the advocate has said that he agrees whatever he say. My lord, there is no. My lord will pass a order. My lord, that is.
Demanding back the matter.
Yes. Remanding, my lord.
Because
The scope of remand. No, no. Let scope of remand. Supreme Court even day before yesterday has also said that if it has been decided, Millard, only out of several issues in one issue. Now, Millard, I have only sole issues. Now the thing is that Millard.
What are you against?
Millard, I am only Millard that rejection. That it has to be by a auditor. Kind 44 AB. Kindly see Millard the rejection. There is a sole point. There is no other point.
By adding bad debt, the turnover will exceed 10 crore.
Very well. I'll come back in 5 minutes.
Very well. Very well. they have rejected my return. I have given two representations. Those were also rejected after considering. Now, my lord, what my fallen from your lordship to remand. I'll just take your lordship to our provisions of PPC. And Millard, kindly see for a moment the scope of remand. Order 41 rule 24.
Like you threshold Millard, he to take so then Millard, I am praying Millard, then I
No, I am saying I am relying on Gujarat High Court judgment.
then Millard,
Gujarat High Court was
Millard, then Millard, your lordship kindly pass interim order in terms of pair F and G Millard, let me allow me to file my affidavit.
stay for the order. Okay, that's clear. Millard, kindly Millard for a moment. Millard, kindly.
Mr. Dasgupta, report will not decide all this.
No, Millard, report had decided in other court.
Maybe in other court.
Millard,
I'm
after
today
Millard,
bound by whatever.
you have said.
I'm not bound by whatever.
No, not at all. Not at all. There must be a Millard persuasive value. Now, Millard, today demanding back, what Millard will get? Will get nothing. Because Millard, after two,
nothing means I
Millard, because after two exhaustive representations, Millard, the same result has come out.
It may not be the same result because this.
But Millard, just
for the court orders.
Very well. Millard, I bow down.
If it is being set aside, it may not be the same result. If it is being set aside, the rejection is set aside and remanded for fresh consideration in light of such an observation. It may not be.
But Millard, he is agreeing that Millard turnover cannot be part.
Neither here nor there. I will not be guided by whatever he agrees. No, I am by my own conscience.
Yes,
Whatever I have, I'll put it on whatever.
Yes,
is there.
Millard, we are not. Now, Millard, kindly also Millard for very well, Millard. I have Millard, I am so grateful, Millard, that Millard expressed Millard's mind. As the advocate, Millard, kindly give me 2 minutes to try. Millard, anyway, I don't lose in that even if that order is passed. Good for me. But Millard, as an advocate, Millard, I have tasked to try before the lordship, Millard, to give our best. Now, Millard, the scope of demanding back, Millard, it only arises Millard, out of Millard 10 issues, it has been decided only in preliminary. To my understanding, because if I go by
with that, there are open remands also for deciding everything.
No, I have Millard, though I was not Millard forcing that this will come, but Millard, I'm carrying a 2024 SCC Millard. For another matter, I'll also let Millard know for which matter. Millard, I'm carrying this matter for this, that beans and roots matter, Millard, where strong energy is my other side. But I was having that in my.
There are judgments of equal weight. I can also show you judgment on remand. I have also been on that side.
Yes, Millard, that Millard, do we have? Millard, we have been on the adversarial in many litigations, Millard.
We have
so Millard, only Millard, my Millard prayer before lordship.
These issues need some expertise to be decided by.
The expert has done his duty.
May not have done rightly. Let him do it rightly. Anyway, you want me to decide it? I will have to decide it. Maybe again I will come to the same conclusion. Because
but for a
dictating orders today.
Give me like 2 minutes. Not even 30 seconds. 30 seconds.
Order 41
rule
not
20
required to be shown. Not required to be
yes.
shown.
Millard, out of Millard, there is only one issue. After two repeated Millard representations, the same result we have got. Even Millard, when they rejected my Millard, initially they rejected my reply, giving the copy paste reply back, and the reason cited. So Millard, there is only one issue, and remanding back to the same person, Millard, with the same issue, Millard, with all humility,
usually done. EPC will, it's not
EPC
like
may not, but the thing is, as there is a scope of
decided, it is a quasi-judicial authority.
Yes,
has taken a wrong decision, may not have understood the provisions of law correctly. If the provisions of law are indicated, judgments are placed. Court observations are
very well. Then Millard, allow me, my lord, remand it back, set it aside, remand it back. Allow us to make submissions before the. Because otherwise, I'm told Millard, it's an open and shut case there, Millard. My lord knows the authorities. So allow us to make submissions, allow us to Millard approve, give our documents in support of our content, and let him give a hearing to us. Isn't hearing.
That he will do.
And my lord will give observation with regard to the order path, the earlier.
That definitely I do. Can we have it today instead? Because I will also need to go through it. So many papers. It will take a lot of time if I start dictating now. It will be easier if I dictate tomorrow. Because by that time I'll be a little handy with the papers.
Very well. Well, in that even may I just give your lordship a reference? Only my lord,
Please.
just my lord take it formally, informally. Just my lord consider my lord 2024. I'll give a copy. 2024 17 SCC 250.
250.
Yes, 250. My lord paragraph. Paragraph 21 to 33.
21 to
33. 33.
3.
33. I'll get a copy and hand it up to your lordship's office.
Very good.
Giving the item number.
And anything else, Mr. Dasgupta?
No,
If it doesn't come, then give it.
Total 6 people. Obliged to learn.
Thank you. Deep program.
Ama.
But Mr. Durrani is in some personal difficulty, my lord. Kindly keep it any day after 23rd. Incident as prayed for by Mr. Chakravarti, learned advocate appearing for the petitioner.
Medical emergency in his family, Lordship. So he is humbly prayed. If only the matter can be kept after 19th, my lord.
19.
Maybe on the Monday, my lord.
Same order for you, Mr.
Maybe on the
An
20th.
adjournment is prayed for on behalf of the petitioner. List this matter on February 24th of 2026.
Yes.
Yes. The returnable of the day of the file Mr. Chakravarti has disappeared. Right? That was returnable.
Another matter. Section 70, Jyotita Lordship, it is 73. Here the matter notice was issued under 73, but did not contain any allegation as to what are the contentions. It was a so-called notice bereft of any jurisdiction for cancelled dealer recovery of it. Lordship,
There was a report supposed to come from you.
Lordship, 15 December, your Lordship, detailed order is there. After that, 2 times it has come for report. I am enjoying an interim protection. Lordship. Extend my interim protection. I am happy.
No, it's there without leave of court.
Without. So I have filed my reply. They have not called me for hearing, in fact.
They won't because they know that it will be unnecessary. When, tell me.
Tomorrow, your Lordship might take up a affidavit if your Lordship kindly business to this time.
2 weeks, deal.
15th
It was passed last year. Yes.
15th December. He cannot 70 this thing. They cannot bring out
That
any.
is why Mr. Chakravarti has disappeared. To give him some hair oil and
Is required from.
very well. Mr. Sanyal, learned advocate appearing for the state The overall.
Now the portal, now they have brought, Lordship may kindly see, remarks is coming in top. Additional notices, orders tab has been merged with notices and order tab. Accordingly, all the notices and orders
So this
issued
is
from,
shown.
now everything will come under single notice. So all these issues of that I was not able to catch that particular.
That is gone.
With
Because
effect
I
of
needed
6th
a
of February.
clarification. Yesterday also somebody was showing me this. I did not.
Lordship, it is from 6th of February. I have taken the screenshot. It came on the portal from 6th of February.
That's what I received.
So Lordship, all these cases of additional notices can now be remanded on this ground because now GSTN has revamped everything finally. January 24, what Delhi High Court had recorded in the order, that is not sacrosanct. There is no records of that, Lordships, from what day it was happened or not. Now this is, there are screenshots available. We have taken PDFs kept with us with date timestamp.
No, but they should come up with something. What is your instruction on from which date it started working? Okay, you should come with it. It's your wing only. You have
No, GSTN, GSTN is a private limited company.
under there is
No, under central. They are, everybody the back, it is controlling the back-end operations. So some states have gone with GSTN for their back-end, like West Bengal. Back-end is maintained by GSTN. Out of so many states, 80%
you have to get that information from
Lots.
them.
The IT department of the state can get.
With the portal, we have seen the portal, the entire thing, because the officers also, they cannot do anything, they cannot help the thing. I will ask the officers to get a first chat. There will not be authentication to submit it before your doctor. It is better if doctor directs the central, in any matter if central is appearing, to get this information from the GSTN. So GSTN will be exact for which date.
I will, in my matter, I'll show. There is now latest, there is a January or judgment of the division bench of Allahabad High Court, where GSTN network was a party. Their affidavit is on record in that judgment. What and Information Technology Act section 12 and 13 has been considered, and a detailed order, batch of petitions of more than that has been passed. I'll take a look.
Yes, next.
Careful.
None appears for the petitioner.
I request Lordship to take 799. It is the same FSC, different financial year. The pleadings and the judgments are better in that. Yeah, I have already. Okay, then 40. I am ready with what, because in that those judgments was more properly annexed. That is right. Here I have come after the appeal order, Lordship, where the appeal got rejected on the grounds of delay. But my grievance before the authority was that the entire proceeding was conducted in a ex parte order, ex parte mode, and that all the notices were under additional notices and tab, and therefore I could not had the opportunity to reply or to proceed enter into the proceeding.
Limitation did not begin because
Lordship.
you did not
Lordship. And that is what Lordship, and that is what
the notice.
That is what, Lordship, the latest two judgments, one by the Honorable Justice Harish Tandon sitting in the division bench of Odisha High Court, and one by the Allahabad High Court, has dealt in this issue of service under 169, read with the Information Technology Act, and stated that merely uploading in the portal is a valid mean of service. There is no dispute to that. At under 169, it's a valid mode. But communication of the same to the SSE, when does the SSE sees that, and whether the email is received by the SSE or not, that benefit of doubt has been given to the SSE, and all the matters have been remanded for fresh adjudication or appeal after 10% deposit to meet the end of the justice. I'll place those two judgments. This is the Allahabad High Court judgment. In Act 799, it is annexed also.
This is one judgment.
The batch petitions were there, so they have discussed. And this is the Odisha. Yeah, very beautiful. It's a detailed. Detailed judgment. It takes down everything. It takes the affidavit of GSTN also, and Odisha has followed suit. What is my page? Directly page para 104 of the judgment of Allahabad. Para 104, it's a summary of the entire judgment. I place Lordship para 104. The Lordship may first take para 96. This is 97, 98. 98 is Lordship wherein the uploading in the common portal has been described by the Honorable Court. Okay. Lordship, page 76, para 98. 96 is also page 76. Lordship. Thus, in any case, receipt under section 13(1) read with 13(2)(a) of the Information Technology Act falls short of communication and therefore service actual or constructive under 169, and it may never amount to communicated under 107 of the Act for the purpose of start of point of running of limitation to file an appeal, as no acknowledgement has been generated under section 12 of the IT Act and no notice has been issued under 12(3) of the IT Act. So, the reference has been taken to the Information Technology Act, and they say that under these two provisions, unless it is shown that it has come to the knowledge of the recipients, communication cannot be done. Service is okay, but communication cannot be stated to be. Then let's
Yes, the similar matter, similar issue. Mr. Suttosatto Banerjee was asking.
That was different in context. It is not similar in the sense because there is an earlier order where the court had directed him to prefer appeal.
But the point which he has raised
may not be fall for consideration in that case at all, in view of the earlier order.
But your Lordship, we have raised similar issue. That's why.
That's raising I may not permit him because I am yet to hear.
Para 98 then. Further, it is doubtful if effects of so-called notice or order communicated to the SSE may arise in law merely on the strength of time of such notice or order entering the common portal of GSTN, from where it is possible for the addressee to retrieve such document to record. It is akin to early stages of postal service, where a letter communication dispatched by post was sorted and kept out the post office nearest to the addressee, from where he could collect it at his convenience. In the absence of timestamp being available, when the addressee may have retrieved that communication, and further, in absence of any notice with acknowledgement, that determination is not possible.
In your case, it was
under additional notices. What you have brought the screenshots. The screenshot, Lordship. My name is there in top right hand side, period 1920. Left side, dashboard, additional notices and order case details. In the top left side, Lordship message. Dashboard, additional notices and orders, case details. Now under additional notices and order, first the intimation, first page, DRC 1A. Then look at the next page. Notices, show cause under section 73. Again, what you may see in the top dashboard, it is all coming under additional notices and tax. From the left hand side, top. And after that, the order, the third page, also under same. So
Yes, what is your instruction?
What if regarding this additional, because there has been change in the portal there. But the date they have issued the super notice was this 2024. 2024 January.
8th of January 20.
And then according to you, what is the change effective?
Change affected your lordship was the High Court. Before that, the portal has been changed from January. So if anything has been done prior to the change, then I cannot improve my post January 2024.
Well, Lordship, with regard to now the current situation, this is dated 6th of February. Now, everything has been adjusted by this. Now the GSTN portal is showing.
Then how is Delhi High Court recording that it has been done?
Look, that was what was the fact. Under the user services, there was a tab notices and orders, and there was a tab additional notices and orders. So if I click on notices and orders, it will show certain notices and orders, not related to adjudication, but only related to returns. And under additional notices and orders, if I would have clicked, then it would have shown me the adjudication related. Now, what Delhi High Court perhaps records is that from January 24 or whatever the date is there, when I click on user services, notices and orders, it shows me two tabs simultaneously. Here, left side, it says notices and orders, right hand side, additional notices and orders. But both are no, but if I have to click again on additional notices and tab, then I can see. It is not that I see both simultaneously on my screen. The two tabs are still
you
there.
have the Delhi judgment.
In fact, that is why this particular from 6th of February, this has come and there was no press release of the GST, and I would have brought Lordship. In the portal, every SSC portal, now this is coming. In January, Lordship, it says. In my case, it is 8th of January.
So in any case, this is prior to that. So why should I go into?
I have asked my because we have seen the portal, but my officers are not able to access the portal from.
So it is undisputed now that in his case. So I will not go into this. I'm safe now for the moment of deciding all this.
There was a lordship what was troubling me. I've asked my officers, but they are not able to get because RTPs from RTP sites, the website is something different. So they have a portal page is designed.
I am for the petition.
Yes.
My lord, on the last occasion, your lordship was pleased to direct me to intimate them regarding the returnable date, your lordship. The BSNL is appearing, your lordship, along with the
BSNL is there, yes.
but the Eastern Railway is not appearing.
What is your case? What
My
has
lord,
happened?
the case is that we have purchased scrap battery from BSNL and from Eastern Railway. Now, BSNL, what BSNL did, the year in which the purchase was made, we have claimed our ITC, but they have not shown that in the same year return. They have shown it in the next year's return. And as such, the ITC which you have claimed, that was rejected by the state authority, the GST authority. And what Eastern Railway did, three issues here, lordship. What Eastern Railway did, one transaction, they have not even shown it in their return. Although all the documents regarding that transaction is here, your lordship, with this petition, and that was placed before the assessing authority as well as the appellate authority. But the appellate authority was of the opinion that since the Eastern Railway did not show it in their return, so we are not going to accept your claim. And the last thing is that there was another transaction with the Eastern Railway. The accountant of the petitioner wrongly, my lord, put the ITC under the IGST head instead of SGST and CGST. So there was a.
So what is your point of contention with the BSNL?
BSNL had shown it in the next year. The year in which the purchase was made. We have claimed the same in the same year. That is 1718. But BSNL has shown that transaction in the 1890s return. So accordingly, when 1718 return was processed and assessment was made, the authority said that we cannot claim it because they have shown this figure in the next year's return. And in 2017-18, there is a huge dues for that mistake committed by the BSNL.
Yes, what is your answer to that? You file a report in the form of affidavit because this oral submission will not do. This is something serious. And why not appearing for the railway?
May I submit before your lordship for the period 1890, similar thing occurred. And that matter came up before Honorable Justice Rajabasi Chaudhary and where our application was allowed. That order may I place before your lordship?
Which paragraph? Paragraph 7. Here, just a minute. What has happened? Paragraph 7. Yes.
or my work. That and the decision which was or 1890, and the that minute we should have processed.
You first file a report in the form of affidavit. This oral submission, I will not pass an order on oral submission. You file a report. And who is appearing for the railways? Because
None, my lord. The main petition was submitted, your lordship will, the affidavit of service, we have also submitted this petition to the Eastern Railway. Thereafter, your lordship will further please to direct us to intimate them the returnable date. That was also done, my lord. My lord, this is the notice was issued, subject to your lordship direction. Well. But original technique.
listen into none appears for the respondent number 5. Then not to the, yes, sir, maybe. Next. Five, yes.
This appeal brought by limitation of ownership. Madam, page 117.
Learned advocate appearing for the petitioner. Learned advocate appearing for the.
Is just to provide you a copy of the.
The copy. I'm handing the copy director compilation.
इथे कोणतं दिलेलं when tell me I have no problem. Tell me a date.
No, maybe one only difficulty one kindly see the chart when I prepared. This is one of the issue is same on all the matters. From item number 5, 301, 302, 303 up to 30554. Well, you won't answer. On the chart, well, this is only with the period is different. Issue is same, my lord. My lord has
One is
decided.
decided, the others can be decided.
Yes, my lord, is only the period is different.
When can we come back on this? Because
Well, learned friend, I need a
next week when tell me only date. 18. Listen. Ms. Mukherjee, learned advocate appearing for the
Okay.
no, nothing is going to be tagged. This matter will be decided. Other matters
have same.
After this decision, we'll take other matters.
I am for the petitioner. We are challenging the input penalty order passed for the assessment year 17-18. What happened in this case, my lord? The assessment order passed in 1st of October 2019, the regular assessment order. Then the penalty order passed, the super notice issued after 5.5 years, in 2024, 25. Then, 2025 on February 17, 2025. The assessment order, kindly come to page assessment order at page, my lord, page 281 of the third volume.
Yes, page.
My lord, page 281, annexure P14.
281.
Yes.
281.
Wait, no, this is the assessment order for the period assessment year 17-18, dated 1st October 2019.
Yes.
Malad, this is the allegation, my lord, in the assessment order. Malad, kindly come to page 282.
This order we have challenged? No.
No, we have not challenged this.
Assessment order?
Assessment we have not challenged. Malad,
We have not challenged any assessment or
Why you are challenging the penalty proceeding?
penalty
applied
proceeding,
by
there
the
is no,
bar?
that because of the reason, two reasons. There is, first reason is there is no finding as such. On the basis of that penalty if there is a finding, then only the penalty proceeding can be initiated against the petition.
Finding?
The finding of if there is evasion of tax, if the cash,
What is
the allegation is that was this one.
What does the assessment order say?
Well, nothing, Malad. Only the question, Malad, kindly page 2 pages assessment order. That is why I'm referring. Otherwise, Malad, page number 282. The issue in question include the high value receipt of cash shown from third parties in response to data. This is the only allegation is there. Undisclosed income reported PCIT after online verification of cash deposit during the demonetization. With regard to only 24,93,805. Disallowance of transaction made in cash. It is observed the ledger account as provided by the assessee company.
Yes, I have read it.
Yes, madam. Then, madam, kindly come to show cause notice at page 289. Well, there is no satisfaction recorded as such for initiation of penalty, madam. Well, kindly see the page assessment of last page 283. Assessed under section 143 of the Income Tax Act, issue copy of a computation sheet and demand notice to the assessee. We did not prepare and we have paid the amount, madam. Then, madam, kindly come to page 289. Madam, the notice was issued for the assessment year 1718, dated 17 February 2025. It is more than 5.5 years. Madam, kindly see the notice. What is the amendment made in the notice? Whereas in the course of proceeding before me for the assessment year 1718, it appears to me that you have failed to comply with the provisions of 269T of the Income Tax Act. You are hereby requested to appear before me either personally or through duly authorized on such and such date on 4th of March 2023. Then, my lord, we have filed a reply. Again, they have issued 271E also notice for the purpose of there is a violation. Well, kindly come to page 290.
290.
Yes, ma'am. Then, well, kindly come to reply. My first reply at page 293, annexure P18.
Yes.
Well, the notices issued under section 271D and 271E. There are no details of any loan, deposit, or specified sum received and refunded by the assessee in contravention of the provision of section 269 SS and 269T of the Act. My lord, it is therefore the notices are vague, leaving before the assessee clueless and wondering for alleged violation. But there is no allegation mentioned in the show cause that I have already read, my lord. But then, my lord, kindly come to page paragraph 3. But the assessment order has been quoted in the said assessment when we have just referred. Then, my lord, kindly come to page 295A. We have referred the 269 SS and 269T. Then, my lord, kindly come to page number 296.
Page 296.
Is my lord D, my lord. C is also in the present transaction referred to the assessment order do not represent either receipt of any amount in the nature of loan, deposit, or specified sum or refund thereto. In fact, in the said transaction, our payment towards express premiums and radiology expenses are not received refund of loans, deposit, or specified sums. Then, my lord, paragraph 4, my lord. No penal proceeding initiated during the assessment proceeding. Well, I have shown the assessment order 283. Well, there is no reference to they will issue the consequential to penalty proceeding can be initiated. It is not reference, satisfaction is not recorded at all. It is submitted that the assessment of the assessee company was made under section 143 of the Act. However, during assessment, no satisfaction has been recorded by the learned assessing officer. There had been any violation of section 269 SS and 269T of the Act. Thus, no penal proceeding were initiated by the learned AO under section 271D and 271E of the Act. And we have referred the Supreme Court judgment. In my opinion, my lord, my humble submission before Lordship, this issue has been covered by the Honorable Supreme Court judgment in case of Jai Lakshmi Rice Mill Limited, my lord. But may I place the judgment in due after that?
We'll come back after.
Yes. The ground of there is no satisfaction, if the satisfaction not recorded,
You
no
are showing a
penalty
judgment.
proceeding, your penalty proceeding
You
cannot
are
be
showing a
initiated.
judgment.
Yes, my lord, I am showing the judgment, my lord, before the issue has been, our single bench has already decided the issue, passed the interim order. In case of Marlin, my lord, handing over the copy of the judgment passed by the coordinated bench. देखें एक बार नहीं मुझे देखें चुके हैं परिवर्तन
Yes.
But apart from that, only the judgment. Subsequently, it was not submitted before the single bench. These two judgment, my lord, the Gujarat High Court subsequently held. My lord, kindly see the judgment of the passed by the Gujarat High Court in case of Parivar Television Private Limited. That has been affirmed by the Honorable Supreme Court, my lord, on 7th October 2025. Recent judgment, my lord. May I place this judgment of the Supreme Court, my lord? It was not cited before the because it was not. When it was 12th June 2025, the interim order passed. And subsequently, this order has been passed by the Honorable Supreme Court. May I read, my lord?
I've read it.
Yes.
Yes, Mr. Lahiri. You want to consider and come back? When should I?
Any day, 13th, Thursday, we will be better.
13th we'll be taking different,
16th?
especially assigned matters.
We'll come back on 16th on Monday.
Listen, this writ petition has been filed against penalty order has been passed or It's fixed maximum.
I'm for the state.
Of the appointment and proportionate law. All are the home guard purely under they are voluntary in nature, but the scheme provides for appointment of the compassionate appointment as well as medical incapacitation. Now, what has happened, my lord? These the son and daughter of the employee made an application before the authority that they are fully unwell, they cannot discharge their further duty. And request was made to medical examinations following the rules. Accordingly, the superintendent of the police considered the matter prayer and it was forwarded to NRS Medical College, Regional Medical Board, which is and they have examined that candidates whether they are incapacitated for further service. Now, my lord, the certain members have been declared and their appointments have been wards have been appointed. But these are the unfortunate petitioners before your lordships. My lord, they have not been given employment till today. The reason that's why, my lord, I moved the petitions, your lordship directed to file a report. The reason they have disclosed that these persons have been declared admittedly, but declared not as on duty. They physically incapacitated when they declared they were not performing their duty. To show they have distinct difference, my lord, they have taken that point. The notification says that while on duty, to show it is not on the duty. Your lordships will consider this aspect of the matter. That I will submit before lordships. Another very important, my lord, the total total 9 candidates have been declared medically incapacitated. Out of them, all have been given appointment, this except the petitioners, although they have on the similar circumstances their case. Now your lordships kindly takes up the petitions. The first, my lord, the application which was made before the authority that starts from annexer P1, page 18, 18.
Yes.
আমার বিনীত নিবেদন এই যে আমি যদুবিন্দু বৈদ্য গ্রাম অ্যান্ড পোর্ট রাধাকান্তপুর রায়দিকে দক্ষিণ 24 নং স্থায়ী বাসিন্দা আর আপনার অধীনে ডিআইজি সালমান নস্কর সাহেবের অধীনে কর্মরত ছিলাম, কিন্তু আমার শারীরিক অসুস্থতার জন্য আমি আর ডিউটি করিতে পারছিলাম না। আমি সরকারি হসপিটালে চিকিৎসা করাই, কিন্তু আমার শারীরিক অসুস্থতার কোনো উন্নতি হয়নি। অবশেষে পাথর প্রতিমা থানার অন্তর্গত গথুরাম গ্রামে সরকারি হসপিটালে চিকিৎসা করিলে অবশেষে আমাকে শারীরিক অক্ষম ঘোষণা করেন, যার ফলে আমি আর কোনোদিন সরকারের কাছে কাটতে পারবো না। অতএব মহাশয়ের নিকট আমার একান্ত প্রার্থনা যাতে আমাকে এনআরএস মেডিকেল কলেজ অ্যান্ড হসপিটালে বোর্ডে হাজির হইবার ব্যবস্থা করেন, তাহলে আপনার নিকট চিরকৃতজ্ঞ থাকবো। Now next page, prayer for appearance before the Zonal Medical Board. আমি বিনীত আমার বিনীত নিবেদন এই যে আমি হোমগার্ড 256 বিশ্বনাথ হালদার আপনার অধীনে বারুইপুর থানায় কর্মরত থাকাকালীন
we have gone through all this.
Yes,
We'll come to the order in few.
Yes,
That is better.
Madam, the P8, if your lordships kindly
Because there is no dispute that you were tested, you went there.
Tested,
Yes,
declared
everything
medical
is-
incapacitation. Well, my
That is not
point.
in dispute. The
No.
only dispute is whether in terms of the notification that they have now
Yes,
on a.
my lord, I'm coming.
Yes.
I'm coming. My lord, I was appealing to your lordships why I was drawing attention before the court, my lord. There is a judgment of the Honorable Division Bench that when you proceeded with, you have accepted. My prayer was accepted. I was examined. You proceeded with. Then you cannot reject the prayer. I will give that citation. Now, your lordships kindly see that I came before this court challenging this memo, page 57.
Page 57.
Yes. You are requested to inform the following candidates who are residing under PS jurisdiction report to Home Guard Office at lot number such and such. Repeat by 25/10/2000 positively along with the below medical documents. What documents they are asking for? FIR, both the complaint information lodged by the complainant information and complaint registered the FIR format. What is the question of FIR? Physical incapacitation, the question. Now, extract general diary entries. What is the question of general diary? Injury reports concerns, period of medical report reviews, discharge certificate, bed head tickets, report from the medical board with specific mention of the incident resulting injuries leading to the permanent incapacitation. Any other document that will issue. These are, my lord, I challenge because I said these are not applicable at all because there is no case of the accident. It is a medical incapacitation. Now, my lord, they have filed a report. Only the two notification they have relied. If your lordships kindly report filed by the respondent number 4, Deputy Superintendent of the Police.
Yes.
All reports are sent. Only this point your lordship will consider. My lord, the page R1, page 9.
Page 9.
Page 9, R1. This is the memorandum. Where in my case, the government, after the consideration, have now been pleased to lay down in supersession of all previous order on the subject, the following terms and conditions for enrollment of the dependent home guards dying or permanently incapacitated in course of discharge of the duty. The physical measurement, education and qualification required for enrollment of the home guard on compassionate ground, including relaxation allowed thereto are detailed in the following table. Age, weight, height, these are the my lord. Now, my lord, they are harping upon the clause 2. The government, after due consideration, have now been pleased to lay down in supersession of all previous orders in the subject the following terms and conditions for enrollment of a dependent home guard die or permanently incapacitated in course of discharge. Now, my lord, the
Last circular.
yes. Now, the circular of 2022, page 11. Proposal for incapacitation. এটা 29 নয় আমরা কবে আমাদেরকে ডিক্লেয়ার করেছি দেখো আমাদেরকে ডিক্লেয়ার করেছে কবে These officers received a proposals from you and hiring prayers of the Home Guard volunteers declared medical unfit by the medical boards for further service have been sent to the Home Guard's headquarters for consideration. It is also noticed that the majority of such petitioners so forwarded and recommended from your end also contain and are followed by the prayers of the medical incapacitation concerns for considering enrollment of their next to kin as a Home Guard volunteer in their place. This office likes draw your attention in geo number such and such issued by the Secretary Department of the Government, West Bengal, where it has been clearly mentioned that such relief can be considered only if the Home Guard declared medically unfit and desirous for getting his next to kin enrolled in his place, receive such injury leading to his or her permanent incapacitation while on duty. In majority of these proposals received from the district police headquarters police commissioner, there is no reference to any such incident encountered and injuries received by the HCB while on duty which led and hard to the permanent incapacitation. It is noticed that in a good number of the proposals that medical board declared HGB medically unfit, not for due any injuries caused during the government duties, but due to physical infirmity acquired due to age. You are requested to please study the GO, enclose carefully, and sensitize all the concerned senior officers under your command to strictly refrain from processing the casual proposals in this line. Only genuine cases should be sent to the headquarters and a signature of the superintendent of the police or the commissioner of police concerned, enclosing detailed report regarding the incident, supporting documents like a journal diary, FIR lodge, injury reports, budget details, distance, such and such. In view of the above, you are all requested to review personally all the proposals sent from unit in respect of the consideration for enrollment of the next two HGVOs who have suffered permanent incapacitation due to injury received while performing government duties, and send this genuine case only in this headquarters after careful scrutiny in your end. All such proposals sent from your ends which have not been created from the headquarters till date and shown pending at your office are now treated as a fill-up subject to fresh submission with the required details as per the circular for consideration under that. You are requested to resend the proposal afresh with the above mentioned documents and specific comments from your end as that incident led to such permanent incapacitation. A tentative checklist of the documents to be enclosed with your fresh proposals is also attached here for your ready reference. You may add additional documents and information also if consider relevant to different establish claim of the officer. মানে আমাদের কবে হলো মানে this circular was issued on 29th September 2022. Mala the all we have been declared medically incapacitated in the year of 2021. 21-22. Before introduction or before this modification or proposal for incapacitation, that's this. Much before that. So, my lord, I make these submissions that this has got no retrospectivity. Moreover, this is a departmental communications to show which has got no retrospective effect. In my case, it is not applicable. And my lord, there is a I only submit before your lordship, Supreme Court, that they are died in harness case and incapacitation. They cannot discriminate, which will be well a violation of the Article 14 also. I shall be placing on judgment 2008 following 13 Supreme Court cases. 2008 following 13 Supreme Court cases, page 730. Para 27, 28, 29. Para 27, 28, 29. When an employee dies in harness, his family is thrown into penury and sudden distress on account of stoppage of income. But while the person is permanently incapacitated due to serious illness and accident, and his service are consequently terminated, the family is thrown into a greater financial hardship because not only income stops, but at the same time there is a considerable additional expenditure by way of medical treatment as also needs for an attendant to constantly look after him. Therefore, the constituency case of an employee being medically invalidated on account of a serious illness and accident will be no less, in fact, far more than the constitution of death in harness. Though generally death stands on a higher footing than sickness, it cannot be then said that the misery and the hardships can be more case of the medical impairment involving total blindness and paralysia, seriousness, incapacity, illness. Another observation made by the High Court is supporting its conclusion that while considering the case of sick employee, the court cannot lose sight of the cases of the sick unemployed. What the High Court apparently means is that if the exception is made for compassionate appointment in the case of an employee medically invalidated, it may account a postage discrimination. That's why I submitted. as a compassionate appointment, it is not expected in case others who are equally sick but are not employees of the government. But the same logic is applicable to death in harness case also. It can equally be said while considering the case of the death employee in service, the court cannot lose sight the case of the death of other employees. Members of the family of a deceased are thrown into the penalty and hardship not only whether the deceased government servant, but also where they belong to a poorer section of the society. In fact, the case of the death of the government servant, there is at least family pension and terminal benefits. But in the case of the death of anyone belonging to the poorer and weaker sections, there is nothing in all to support their family. Should compassionate appointment be therefore stopped, even death in harness also? The issue is complex. Comparison with non-employed is neither logical nor sound. When a compassionate appointment is dependent on the government servant who dies in harness is accepted to be an exception in the general rule, there is no reason or justification to hold that an offer of the compassionate appointment to the dependent of the government servant who is medically invalid is not an exception on the general rule. In fact, refusing the compassionate appointment in the case of medical invalidity, while granting the compassionate appointment in case of death in harness may itself amount to a hostile discrimination, while being conscious that to many exceptions may dilute efficacy of the Article 16 and make it unworkable. We are of the considered view that in case of the dependence of the medically invalid employee stands on the equal footing to that depends on the employee who died in harness for the purpose of the making an exception to the rule. For the very reason for which the compassionate appointments to a dependent of the government servant who dies in harness are felt to be valid and permissible. Compassionate appointment to be dependent and medically invalid to government servant have to be felt to be valid and permissible. We are the submissions of when you have asked me, that you accepted. You asked me to appear before the medical board. Medical board examined. Medical board declared. You asked me to appear for your further course of actions. SP was directed to intimate. The officer in charge of the local police station asked me to go there. And I was not given appointment in the similar circumstances. I have categorically mentioned those who are on the KK Chilo Dakoto, they have given appointment. Now your lordship kindly have a look at this judgment. Someone tell me can 2012 to change and page 75. Para 3, they are also model the whether the this was the compassionate appointment. The question was when the other division bench decided the issue, they know the below aged candidates will not get the appointment, whether the other division bench can consider. One of this issue was considered the para 3. Sri Bali has distinguished the decision of the division bench of Sajal Kumar Mondal case. According to Sri Bali, as the prayer of the compassionate appointment was already in process, well, I was harping upon it. As according to Sri Bali, as the prayer of compassionate appointment is already in process, when the applicant had attended the majority, in the meantime, the said decision Sajal Kumar would have a later application. And furthermore, when the respondent number 2 has himself sought for clarification from the respondent number 1 as to whether the rules be relaxed for the purpose of giving compassionate appointment, the situation cannot remain static. Then I will be para para 10 onwards, if your lordship can do. We propose to do neither for the reason which we will set out here and there. There is a very thin here split difference in this issue, which Sri Bali has sought before us and appeal against the order passed by the Honorable Semi Judge in WP number such and such. We would not do anything different, but we would simply do it in a different fashion that will make all the difference itself as it would be manifest from the order of the proposed to be passed by us. Ordinarily speaking, the Honorable Secretary was absolutely correct in his lordship's approach on the strength of the decision of the Sajjal Kumar Mondal case, as otherwise the provision of Rule 14 of the said rules, which has been interpreted in the order, if it has been given in the plain meaning without any amplified interpretation, that the way the applicant would have hardly in case of the applicant. But as we have said, although we will not do anything different from the statute as is necessarily forbidden. But in the event, if we look it is different way, perhaps it would not foreclose forever to the Kumar's Mondal case, Supra, right to applicant who has a case before us, we have perceived from our appreciation of the entire issue. Again, the cost of the litigation, we would emphasize that as on 11/2/2002, the breadwinner of the family was lost when they claimed him. That resulted in the applicant being of the late teacher to seek for compulsory appointment immediately thereafter. In other words, he has a minor when a such claim was made. Obviously, the division Sajjal Kumar Mondal case has with the full appreciation. He cannot be rescued himself from the same position as the litigator has lost a fortune before the honorable trial. But there is a rider. As rightly pointed out, Sripari, that on 31/2006, the respondent number 3 had forwarded the application to the respondent number 5, the chairman district primary school council Paschim Mendipur. This would bring us to a very important aspect, the said matter. At the point of time when such facilitation of the application was made by the respondent number 3, before the respondent number 5, the district primary school council, the applicant had attended the majority as he crossed the 18 years according to 3. Therefore, as we have found from the papers which are otherwise unimpeachable, as they are documents of the office of the respondent number 3 and the respondent number 5, that on 3/5/2006, the respondent number 5, the district primary school council, had processed the application before the respondent number 3. All the exercise took place when the applicant was measured. Obviously, the rigor of the said division page which has been referred to by the honorable senator would have no application, as at the relevant point of time when the fulcrum effect of the application was reached its fusion at that point of time, the applicant was very much in measure. There is another aspect of the matter. If we abide by the communication between the respondent number 2 to the respondent number 1, the affidavit filed by the respondent number 2, that the student present clear that the last line of the said. In the above circumstances, he requested to let this office know whether he is relaxed or not compulsory ground. Supporting documents are before there. We are not apprised of any action taken by the respondent number 1 person thereof. But is more that the respondent number 2 has himself in a contrary with regard to the fate of the applicant. As such, when the situation was an flux as evident from the confusion which dominated the mind of the respondent number 2, no conclusive decision was arrived at. And this is simply going by the rule book and to abide by the decision of the division bench of the opposite school. Also, it is beyond quite distinction. In our opinion, does not serve an ultimate end of justice. Accordingly, we set aside the order under appeal and giving the respondent number 3 to take the application for compulsory appointment with the appeals from the But this matter was also where
Already acted upon.
Yeah. Para 18, if you notice kindly. Yes, para 18.
Yes.
It may be argued that the application for compulsory appointment is need to be made within 2 years from the date of such date of Rule 14 of the said rules. Whether the applicant would come within the rigorous of the same is a question of required slight discussion. He lost his father. Now, as we have found that on such and such date, the respondent number 3 had written to the respondent number 5 for necessary action in respect of the pair of the compulsory appointment, without going into the actual date on which such application was referred, as to whether the applicant was minor at the relevant point of time, since the respondent number 3 had already acted upon the application for compulsory appointment, and the said process being facilitated when the authorities have processed on such basis, it can be deemed that they have accepted on the part of the claim, and it cannot be made to abandon midway, more so in view of the confusion that pervades the minds of the respondent. So they have accepted because your lordship said the writ petition টা
আমাকে এরপরে মেডিকেল এক্সামে আমাকে ডেকেছো
হ্যাঁ তা তো বটে।
মেডিকেল ইনকাম 37 পর্যন্ত ইনকাম এই লিস্টের মধ্যে আমার নাম আছে কাস্ট লিস্টে আমার নাম
এইগুলো সবাই যেটা now your lordship kindly turn page 45. Page 45, P5. Please arrange to inform the following candidates who are residing under your PS jurisdiction to report to Senior Adjutant Home Guard, Kakdeep Suburban Police Station is repeat and hours repeated 04-2022 on 10 hours positively for their physical measurement for enrollment of Home Guard organizations on compassionate ground, along with all testimonials, along with the copy of the recent passport size photo. So, my lord, the issue was they are directed to come for enrollment. Your lordships kindly see the language. They positively their physical measurement for enrollment as a Home Guard organizations. Matlab primary selection, thereafter medical and all police verification. It is in the service all. The show, my lord, in all the petitioners have given this call, page 45, 46, 47, 48. Now page 53, your lordships kindly have a look. This is the letter from Superintendent of the Police. You are requested to inform the following candidates who are residing under your PS jurisdiction to Kakdeep such and such is repeat by 5/9/2022 positively along with the below mentioned documents for enrollment in the Home Guard organization on compassionate ground. What they have prayed for, certificate of the applicant, good local reputation or not being involved in the criminal case, birth certificate applicant, copy of the passport size photo, last detailment of the comment certificate of the disease, death certificate of the disease, if any. That will be the. Now the name of the candidates have been included. All the petitioners' name have been included in the. Now, my lord, from this list, 13 persons have been given appointment that I have categorically mentioned in paragraph 11. That it is a state after submission of the required documents. Devnath Chakraborty, Rumpa Nashkar, Sushant Ranjan Tripathi Haldar, Shubhadeep Das got their appointment, but petitioners are being deprived till date. I have categorically mentioned these are the persons where, my lord, the medical examination were held. We have been declared by the permanent medical board, permanent incapacitation. They have been given appointment, but we have been denied. And my lord, if the similar situated persons, when the offer was given or appointment was given, my lord, that you cannot discriminate this when the similar situation দিয়েছো সমর থেকে সমন্ত 2022 SCC online SC 641 para 17 if your lordships kindly. We are also inclined to grant interest 17 para to the appellants on the areas at the rate of 7% which would be payable to the effect 1st September 2000. We have fixed the set date for the grant of interest as the respondent corporation has accepted interpretations such and such. Now the court held this would have avoided unnecessary litigation before the courts as was held in the state of Uttar Pradesh versus Arvind Kumar Srivastava. The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matter more emphatically as the service jurisprudence evolved by this court from this time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated person did not approach the court earlier, they are not to be treated differently. So, Shomela, the similar circumstance persons, this is my humble submissions. First, allow me 1 minute.
Participation.
Firstly, circular of 2010. You cannot discriminate the depth, and I have seen. Secondly, the 2022 notification. That is the whether you can carve this 2022 had got no retrospective effect. Thirdly, the people in the similar circumstances you have allowed, you have given the appointment. You cannot deny on the basis of the notification of 2022. And my lord, very interesting. They possibly there are 17-year losses can be have a look. The point they have taken of their report.
Yes.
That it is also important to note that the petitioner, despite having full knowledge of eligibility criteria for compulsory appointment, as laid down in government order number such and such, took a chance to participate in the selection process, and now they have not been given compulsory appointment owing to a challenge on the input communication. Is it the principle laid down by the Supreme Court or our High Court that I have taken a calculated interview, that open advertisement was there, I made an application and I took a calculated chance and turning back and participated. My humble submission would be, this is Lord 6. My prayer was considered by the authority. I made an application, or my father made an application for medical verification. That was done. Everything was completed. Local officer in charge was asked to verify their documents, and we have been directed to report the same with them. And can it be said that you have taken a calculating chance? The compulsory appointment is a calculating chance.
Yes, Mr. Samantu.
From my understanding, this matter, one is the factual one, and the legal one. And it takes up the nonsense.
Yes.
The understand has this matter has here two courts of argument that their 2022 notification had no retrospective, and there is a discrimination yet on. So kindly takes up the 2010 notification first.
Yes.
Thereafter we come to 2020. And I have any of respondent number 3 affidavit or any of the kindly takes up. Page 7 of the affidavit.
Yes, yes. 2010 circular we are on.
But they have placed it for us. In order of
Second paragraph.
Second paragraph.
Last line is what is important.
Second paragraph. The government of the due consideration have now been used to lay down sufficient. So all features or subject following terms and conditions enrollment dependent to home guard dying or permanently incapacitated in the course of discharge of duty. 2022 notification, that is not a new notification, that is a clarification memo in response to or in continuation of this notification. There is nothing new has been said. So kindly takes up the 2022 memo itself. The next page 9, next to next page. Here the underlying concept is not the same. He will be or he must be when what year of the medically incapacity.
Now, Lord, the next question was put to me perhaps, or the board was put, that in the paragraph number 11 of the petition, it has been stated, Lord, page 7, paragraph 11, that several parcels have been given or favored, not the evictions. But Lord, may I just clarify, Lord, I have, as per the law situation, I have 5 affidavits. The point will not give the opposition, so I don't have the opportunity to deal with all these allegations.
You want an opportunity, I can give you, because later on.
Last occasion, I prayed for your Lord's was pleased to say that file the affidavit, the form of affidavit, if it is required, during the course of hearing, I will grant you.
Mr. Bari, if he seeks that on this ground he wants to file opposition that he has not discriminated against.
Admitted positions.
No,
He's not admitting that, because ultimately it will be difficult if it walks up to the division bench on this ground alone, whatever order is passed, because this factual matrix. Or
they have dealt with.
We have not dealt with. I have the main issue.
Right. Without affidavit in opposition, he cannot deal with that. If we are only on the point of interpretation of the notification, that is different, that can be done. But if this point of discrimination.
And the Article 14 part. But I have not dealt with that.
Your Lordship, can you? This one number 4, report.
Yes. They have said they reserve their right to file affidavit in opposition.
Para 13.
Para 13.
Para 13 of the report filed by this one number 4.
Yes.
That the grievance of the petitioner confronts the allegation of discrimination is entirely specious or misleading. The petitioner had sought to draw a fallacious parallel with other candidates who were granted appointment. The other individuals named by the petitioner are found to be eligible under the strict parameter of the scheme after they had furnished their complete and correct documentation, which was then duly verified. What is this?
I have indicated.
So they say that. Then that means they say that they were found to be eligible, means on all parameters, means they might have been incapacitated in course of duty. That might be an indication, because this.
But I hadn't been said anything. They have mentioned categories that I have
This because Mr. Bari, they have also said in the same breath in paragraph 20 that they reserve their right to file their affidavit in opposition.
That is always there.
So Mr. Bari, if we are on this issue, then in that case I'll have to invite. If we are on the interpretation issue, we can proceed, because that will be an embarrassing situation for the court also. You know the writ rules. If he seeks an affidavit in opposition, I cannot say no to him. Or if we are proceeding on the basis of interpretation of this circular itself.
And that is one of the matters that you give the other persons similar circumstances.
Yes, but similar or not it has to be similar in all cases. But that also, there is another line of judgments, Mr. Bari, you know well, that Article 14 is a positive concept. It is not a negative concept. If I have committed illegality or arbitrarily I have granted somebody something that may not give you a right, what would happen is that person may be deprived of the job.
It is not a question of negative. It is not a question of judgment which I have cited before your lordship. The discrimination between the. If it is taken up for consideration.
No, that was on the on a different footing. That judgment was there should be no discrimination between two classes of deprived persons, in the sense that there is one class whose breadwinner was lost to death. There is another class who lost the breadwinner because of incapacitation. So both these classes are deprived classes who can be considered for compassionate appointment. It was on that line that the judgment was.
That will help me.
Yes, that is this. But here both the classes are of people who are claiming compassionate appointment on ground of incapacitation of their breadwinners. It is not a case of one class saying claiming compassionate appointment on ground of death, another claiming on ground of.
They are trying to. The first, the compassionate appointment is there. First, the losses can have.
Their only case, as I have found in the report, is that
I'm not on duty.
incapacitation should be in course of duty.
From the repetition, you see, this is a joint repetition. I shall be inviting your lordship that categorical mention when some of the petitioners said when I was in.
Then Mr. Bari, better I call for affidavits. Unnecessarily, I'll decide something on this issue and then it will turn nowhere.
What should I say?
No, don't leave it to me. I am not the person to decide. It has to be decided by amongst us. If you harp on this point, then in that case, affidavits, yes, of course, because it's a factual issue. Factual issue.
Even just your lordship said, even it is taken into consideration, it was wrongly given, then your lordship should say the negative utility will not. So your lordship decide this issue on the basis
of the interpretation, we'll do that. Yes.
And one thing I tell you, lordship, if your lordship can see the 2010, which are classification of the class.
Yes.
The paragraph 2. The government, after due consideration, have now been laid out in supersession of all previous orders subject to the following terms and conditions enrolled in different home dying or permanently comes in the course of discharge duty. The physical measurement, the dying or permanently incapacitated. You are considering that, although there is a provision, other provision can not have said so. And you are depriving other citizens. When admittedly it is not the fact the private body, private medical board, it is your product. You asked me, you constitute the medical board. You declared for further incapacitation. And when you took a step, you proceeded. This is your lordship will consider. Thank you.
The person's name is Frederick at case 7 para 11.
Yes.
Okay. And we take one by one. First one is Jeddah Kapoor.
Yes.
We have incapacitated. Whose verification order was passed and he joined prior to issuance of 2022. He joined. And so there was no for him to furnish all the bills as indicated in 2022. And as of Susanto Ranjit and the fifth one, Subodhi Das, where died while he was in so he fulfilled that criteria also. So they are escaped from that plan. Now may I but and it picks up page 4, para 7 of this section.
Yes.
That is stated as some of the petitioners have not inquired in the requisition date that the medical intervention of their father was the discharge of any of such on accident. Petitioner have in fact admitted by central these are the documents. No, extremely sorry, madam. I am placing my report to that. Extremely sorry. Report filed by the blood respondent number 3.
Yes, I have read that. That is your submission. I have read.
Those circulars you have lordship have done through that. May I just say
the regard to the judgment cited by Mr. Bari. Kindly take some fast. Volume 3, 770.
Yes.
This lands on 27, 28, and 29. Kindly takes up the paragraph 30.
2008.
2008, 13, and 67, 70.
আমারটাই বলছি।
হ্যাঁ। 30. There are of course safeguards to be taken to ensure the scheme is not misused. One is to ensure that mere medical unfitness to continue in a post in a appointment. The government servant should totally cease to be employable and become burden on the family. To warrant compulsion of appointment to a member of the family, another is barring compulsion of appointment to dependents of the family who seeks voluntary retirement or medical ground on the verge of superannuation. This could observe in Ramkesh Yadav, suggestion. But for such a condition, there will be a tendency on the part of the employees nearing the age of superannuation to take advantage of the scheme and to seek voluntary retirement at the fag end of their service. It is not service on a medical ground and thereby virtually creating employment by successor. It is not permissible for the court to relax the said condition relating to the age of the employee, where whenever a cut-off date or age is prescribed, is bound to cause hardship in marginal cases, but that is no ground to hold provision as directory and not mandatory. But this judgment had by Mr. Bari cannot not applicable in this case. Can it take up this second judgment?
Yes.
My Lord, Gopal Mondal, 2011, SC online, P441.
Yes.
Here, the Lordship has punished notice, yet placed para 3, 10, 11, 40. This paragraph says that you will be given an opportunity to petitioner therein. When if you are a minor, you don't get the chance to apply when the terms come. So it was this case was considered in that school. With regard to the third judgment, the 2022 SC online SC 641 para 17 the lands has been placed. But here my submission will be the Lordship very much aware of the fact that Article 14 never says of any negative equality. This is submission with regard to this. So may I place the judgment from my side?
How long will you take? Because 3 p.m. I have original site.
I will take at least 1 hour.
1 hour.
I have to place 21 judgments.
21 judgments don't place. Place your best judgment. Why will you place 21 judgments on the same point?
No, not same point. There are points. But our High Court has recently, on the 25 December, has decided.
Place the latest one. Don't place 21 judgment. Makes no sense.
Lordship, so please, Lord.
লেটেস্ট দিয়ে দিলি তো
Yes.
Deals with the judgment which I intend to place before loss.
Yes. What is the point on which you want to place the judgment?
Here, there were 3 points. One, the compulsory appointment cannot be the rule of the society.
That is settled. No judgment required. Next.
Second, we cannot go beyond the notification or the.
That is also settled.
There was a suppression. Here, there is no suppression.
On that, no judgment is required. Is there any dispute as regards the interpretation of the statute? I mean the notification in course of duty.
No, there are no course of duty.
The meaning of in course of duty is that in dispute? You are interpreting it differently. Petitioner is interpreting.
Only 2 points there. I will rely on that from this judgment. First is not the rule of the society. There
That is settled. That in the compassionate appointment is an exception to the rule of employment under Article 60.
I have the Supreme Court judgment also, but I need my compassion. 25.
Not required. That is settled.
I
You
tried
want-
my best to
No,
bring
that's
your
right.
lordship.
Actually, we have to see the time constraints also.
Just like that. Let me give any opportunity to come back.
Tell me when you want.
Any.
You want to cite. Mr. Bari, tell me. He wants to come.
I didn't, if required, I shall reply, otherwise, this is the only.
He needs to satisfy himself that he has argued. I won't stop him. Tell me. Tell the time. Tell it.
Any something to lordship.
Up to you. I come every day. You have to say which day.
On 12.
March. আমি চলে যাবো না বিলিং করো কালকে
কালকে তো হবে না। We don't have it this week. No fixing time. Tomorrow there is already a matter fixed at 2.
India, except
Next week,
No, I will be for other reason, I will be.
I understand. You give me a date.
I indicated the last date. The bar will be there.
তাহলে মার্চে কত?
মার্চে 6 তারিখ।
After 6 months.
6th or 7th February, can it be? 7th.
7th is Saturday, 9th.
6th.
6th.
9th, 6th.
6th we can have. 6th you want, I can have it. Heard Mr. Bari, learned advocate appearing. It's
Send the file. Send the
in
file.
the meantime you file it.
Yes, that will be better.
That's better. তাহলে ওটা কেটে দিন। উপরেরটা কেটে দিন। লিখুন। Mr. Samanto, learned advocate appearing for the state respondents, seeks time to file affidavit in opposition
I will bring my request. Get that also. Yeah, I'll be-
after after hearing the parties, after the parties were heard at some length. Comma 2026. Assigned a hearing, assigned matter is happening. It will appear under the assigned heading. On that day, we'll decide.
That will not get chance.
No. Assigned every Friday I take. Every Friday I take.
So just to fix the time.
No. Come with the affidavit, we'll fix it again. Next. Next. Chalo. Original site to call.
Yes. Milord, for Milord, upgradation of item number 42, goods have been seized more than 6 months ago. Milord, they will go bad, Milord, in March because it's a flavor, orange flavor, which is used in food items and perfume. Milord, I'm seeking release of the goods unnecessarily, Milord. They've been lying.
Item 42.
42, Milord.
You put the other side on notice. If they don't appear, if despite upgradation, I won't take.
I will serve them today itself. Your Lordship will kindly
They
fix a
should be
date.
here.
Milord, tomorrow would your Lordship take it up?
Tomorrow or day after, whenever it is, you tell them that you have made a prayer for upgradation.
I'm so grateful. Milord, the slip is here, Milord. The urgency is noted.
Very good. Grateful. चलो
For the petition.
What is this matter?
The interim order is expiring and the affidavits are complete. It's ready for hearing matter.
What is the point?
My lord, there are 4-5 points. My lord, first, of course, the FAO point is available, faceless. Second point will be, my lord, it is for the assessment year 17-18. My lord, we will contend that it is barred by the laws of limitation as per proviso of 149(1). My lord, then one another.
Rajiv Bansal doesn't take care of this.
No, my lord, not first. My lord, and Rajiv Bansal, they've even conceded for 15-16. And my lord, one of the very interesting points is that this is in then 148 AD. Now it's 123. So, my lord, what is there that earlier in 148 AD, there was a time limit that the assessing officer shall pass an order within 1 month. My lord, here from the records, you will see that there is no that 1 month the order has not been passed. And on the way, my lord, the approval, another point is that the approval is also less than what they have made the additions under 151. The approval amount will not match with the actual addition amount.
You filed your opposition to all this?
Yes, that is the main contention of the SSC before filing the petition. And now the supplementary contention. But I was satisfied, Lordship, the contention of the SSC that the amount of approval that is not matching with the that is the main point they have argued and got this stay, and rather I respectful submission before Lordship, Rajiv Bansal take care of 17-18. And the other point in merit, whether he can argue or not, but the point of matching that is there. We have filed our opposition.
This matter has been mentioned for extension of interim order.
My lord, in this matter, my lord, the interim order has expired in December, end of December 2025, my lord. Due to mistake, my lord, this could not be extended.
What was the matter, Ms.
My lord, there are matters are canvassed on several grounds. One is the Jaufau issue, which is now before the Supreme Court on various dimensions. The Supreme Court has admitted and issued stay in some of the matters, has not issued any stay in some of the matters. It remains a very live and burning topic before the Honorable Supreme Court. Apart from that, my lord, my petition survives on other points regarding natural justice and all. And one more point, my lord, the affidavit in opposition has been filed by them. The reply, my lord, the draft is ready. I shall prepare it within.
I am reimposing the interim order for some time. This is an application
income tax authorities.
You are appearing. Yes.
By this writ petition, primarily I challenge the non-communication of an order under Section 127 of the Income Tax Act, for transfer of my case from Kolkata to Dhanbad under the Principal Commissioner of Income Tax, Patna. May I state what gave rise to this present proceedings,
Why, on what ground are you challenging the transfer?
Milaj,
On what ground are you challenging the
Milaj,
transfer?
my primary challenge is that I have not been communicated this order against which the transfer has already occurred. I can only see it on my income tax portal that my jurisdiction has been changed from Kolkata to Dhanbad. There was a show cause notice. There were two show cause notices. I replied to both. Milaj,
No order has been communicated to
no
you?
order has been communicated to me. Milaj, this is my case. And Milaj,
No, but you were given a notice to show cause. That notice to show cause, you replied to that.
yes, Milaj. There was the last show cause notice, Milaj. I was issued on April 8th, 2025, appearing at page 32, Milaj.
His transfer order has not been communicated to him. That is his.
Lordship, today I'm in a small difficulty since this matter was we have been appointed, but the copy of the writ petition is not served upon us till now. Your Lordship, if a copy of the writ petition maybe
Serve a copy of the writ petition.
we'll come back with the instructions.
When can you come back?
Lordship, a week's time, Your Lordship.
I have already served a copy. I'll serve another copy, Milaj. My only apprehension, the reassessment proceedings at Dhanbad has already been initiated. On the last occasion when I mentioned, Milaj, on 6th of February 2026, Milaj, 148 notice has been issued by the income tax officer at Dhanbad. So, Milaj, is that, Milaj, only time is of the essence, Milaj. That's the only.
148 notice has been issued.
It has been only issued. Yes.
You have at least 30 days to file your
Yes.
return.
Yes, Milaj.
Before
Your
that,
Lordship, we'll come with an instruction.
This writ petition lays challenge to
Krishna, my lords.
My senior, Mr. Kobi Bhoni is with another matter, so not today.
My lords, I'll not
Not
stand. My lords. Although, my lords, this proceedings, my lords, the reassessment notice has been issued to the non-existent entity, my lords. My lords, more.
Yes, what happened there?
Milad, on the last occasion, I'm given to understand that my junior had
An
provided
order was given, yes, I recall.
Milad, as per the Supreme Court judgment, Milad,
Matter has been remanded.
matter has been remanded to the Honorable Sestat. Now, Milad, it will be adjudicated on merits. Now, Milad, on behalf of the company, what I have been instructed, I have been given to understand is that an early hearing application is being filed to to fasten the procedure of hearing the appeal on merits on the demand of customs duty liability. Milad, that is the status. It has not yet been filed, the miscellaneous application, but I'm given to understand that application is going to be filed in a day or two before the sestat. So, Milad, this is the up-to-date.
Yes, but this has nothing to do with that.
Milad, this has something to do with that because, Milad, the primary issue from which these proceedings has come to is that there is a
this writ petition, the genesis of this writ petition was that the sestat order is in favor of the company, therefore
yes,
you
Milad.
should be. Now the order is not there.
Yes, Milad. Now,
so what this writ petition, you should also go back to the sestat.
yes, Milad. But the only question would then remain, Milads, is that on the last occasion, the Honorable Sestat, Milads, one of the daily orders has been said that let the final matter be concluded. Why there's a correlation, Milads? Kindly give me 1 minute to explain, Milads, between the main matter of the company and my case is because for the company, it is a case of undervaluation of goods, which has resulted in demand of duty of customs. I have the director and the foreign supplier over here. Mr. Naveen Goyal is the foreign supplier, and Praveen Goyal, who's in the second writ petition, he's the director of the Indian company. It is said that they have assisted in this alleged undervaluation of goods. So, Milaj, that's why it is connected. Milaj, on the first occasion, the matter was dismissed by the Honorable Sestat only on the ground of DRI.
But in any case, now
Yes, Milad.
as the position now stands,
Yes,
there
Milad.
is an appeal against the order passed by the appellate authority before sestat.
Yes, Milad.
That is the position.
That is the
We
position.
are back to square one.
Back to square one.
Your writ against the sestat's order dismissing your application
Yes, Milad.
cannot be taken upon merits because sestat has not decided on merits.
Yes, Milad.
So it has to go. I can extend the time for you to go back to sestat again and make your pre-deposit
Milad.
for your appeal to be heard before sestat. That is all that I can do.
Yes, Milad. Milad, if I may press one point, is because on the last occasion also, Milad, this was the
No, on the last occasion, the situation was different because the sestat's order was in your favor in some way.
Yes.
The company's liability was absolutely gone. So you saying that you could say that since company itself is not liable, how could I be liable? Now Supreme Court has turned everything upside down.
Yes,
Now
ma'am.
it has gone back to sestat again.
Yes.
There is no more there.
Yes.
So there is an order of imposition of penalty on you as well as the company. So why
Yes.
should I entertain now?
Milad, my only point
And
is
that too in view of the division bench judgment saying that I will not interfere.
yes, Milad, my only point was on the last occasion, division bench, even when the order was against us, even the demand was against the company also, over there they sent us that you go to the appellate forum, which is SESTAT. We approached the appellate forum. One of the reasons why we did not pay pre-deposit was that my right has accrued. One of the reasons. I am not saying that is a legitimate or that is a question which will be answered in my favor, but
No, before sestat, you did not pay.
I had not paid pre-deposit.
Yes, that's it.
And
the division bench said that you have to pay and fight your appeal out.
yes, Milad. Now, Milad, the thing is that today when I go to Sestat, Milad, this issue of pre-deposit would still prick the petitioner. Milad,
Has to.
I understand, Milad, but
It's only a pre-deposit. It is not something that is not going to be refunded to you. It's only
Yes.
pre-deposit. It's not a penalty.
yes,
If you win, it will be refunded. If you don't win, it will be adjusted.
yes, Milad.
So in any case, it's only a question of making payment of pre-deposit.
Yes, Milad.
So why should I unnecessarily keep this pending?
Milad,
It has been pending since long.
I understand, Milad. The only way, Milad, the only plea I take is that, Milad, that since so much time has passed or elapsed, my point is
that had elapsed because it was pending before the Honorable Supreme
yes,
Court. Now before the sestat also, if High Court has to wait, that
not at all. I'm not saying that the High Court should wait for sestat. My point is that on the question of facts, whether there is an undervaluation, whether there has been any assistance to this undervaluation.
sestat will decide that.
Yes,
because if I decide that, what will sestat decide? Is
Milad,
the company's appeal?
I understand, but that has to be primarily first decided in the case of the company, not
So
in
that
this.
is why you also go before the sestat only, because this is what is to be decided exactly by the sestat only. Why should High Court keep this writ pending before it?
Milad, the one reason, Milad, that has occurred to me in past few days is why should this High Court keep it Milad? Because one reason that has come, I kindly give me 1 minute, I'll explain why. At least I'll make an attempt. Milad, that this case, your lordship has entertained me for a long period of time, but this case has also been subject to multiple changes and multiple scenarios being enacted. Now, Milad, one such scenario is that there is an early hearing application that we are going to file and try to get the matter heard on merits against the company. Milad, if that order is in our favor, Milad, again, circumstance will change. So, Milad, my only plea is that until that final appeal is heard out on merits, Milad, let this key be kept pending at the writ court, because today I cannot plead my innocence when the order is already kept against the company.
Opportunity, all I can do is I can extend the time for you to go before the or I can grant you liberty to approach sestat with an application seeking pre-deposit, explaining why you could not pay it. If you can pay it, sestat will entertain your appeal. That's all I can.
Otherwise, this reach is infractuous.
Because it doesn't make any sense.
It is giving them enough opportunity, I think. Please come to opportunity.
Because Milad, if it can be heard, my petition can be heard with the main appeal also. Milad, because over here,
you go and make that prayer before sestat, but it cannot be at the cost of not making pre-deposit. Pre-deposit has to be made, because how can you bypass law?
Because Milad, the entire demand of duty has been paid. The entire demand of duties of 96 lakhs. Milad, may kindly appreciate. Demand of duties 96 lakhs.
Bench, sir, I cannot.
I understand, Milad. But if I may just say one point, Milad, that Milad, against the demand of duty, I have paid the entire demand of duty. The company has paid entire 96 lakhs of the differential customs duty. Milad, and that they have kept as pre-deposit, or it's the nature of deposit with the government. Milad, still it's heard on merits. Milad, if that can be kept and my appeal, these two personal penalty appeals can be heard along with the main
penalties are separate. It's not your penalty. You are against your separate penalty order that requires a different pre-deposit.
Yes, ma'am.
How can their pre-deposit inure to your benefit?
Because Milad, it would be 7.5% of 96 lakhs. But over they have paid entire 96. I understand the 7.5% of 20. Over here, the personal penalty is 23 crores, Milad.
Then the conclusion is they don't file an appeal. They don't.
Because there might be a scenario that because of not being able to pay pre-deposit, the company goes scot-free tomorrow, saying that there is no demand of duty, but I'll be strung to the noose because the bad law is also good law if I don't challenge.
You're the director.
So
you have responsibility. That you have to do, because penalty is on you only, and at the first instance, your challenge to the writ court to the order of penalty has been annulled by the writ court, saying that you go before then I'll be doing the same thing which the division bench asked not to do. How can I do that?
Milad, I'm not saying to entertain this writ petition. I'm saying
the writ petition pending is also the same thing. Why should I keep it pending?
Milad, because circumstance may change. My only plea is that because I have
change, you come again, go before the writ court, or carry this order up to the division bench and get an order, because after this division bench's order, I should not.
He's a nagging child.
Where is the orders? Where is the order passed by the honorable division bench and then the single bench order?
Page 237.
Page 237.
Part of volume 2.
And single bench?
Milad, the honorable single bench decision on page 202. Volume 2.
लिखे this writ petition
If we are served on the customs, lordship is against and lordship is against. I'm handing over.
Mr. De, my lord, he has been instructed to appear, but he has been told that till date the department has not received the brief. So, my lord, may I pray one thing, my lord, if your lordship kindly take up the matter day after tomorrow so that we can ascertain from the department whether they have received the copy or not.
Day
Thereafter,
after
your lordship pass the order.
Day after tomorrow. Purshudin দিয়ে
My lord,
Lordship, item number 9, I appear for the petitioner. It's the same bunch of matters that was being argued on the last occasion. We've given an affidavit of service.
Mr. Advocate Mr. Kundalia.
Kundalia is appearing.
Yes. Lordship, a similar matter is being considered by your lordships.
That can be taken up. My lord, only one request, one hard copy.
I'll give that to Mr. Kundali. I cannot deny that. I'll
serve on the advocate itself rather than the department.
I also
Look at the sizes of
1600.
all are relevant. All pages are relevant.
Lordship, this
impugned order
95% will be irrelevant. Only 5%.
Lordship, the impugned order is around 1600 pages. That is where
Impugned order
the
is 1600 pages. 1600 pages impugned order.
1600 pages is the impugned order. Then just see
My lord, more
and then there's a show cause notice, Lordship,
show cause
preceding
notice
that.
is above 750 pages. That is why altogether all the documents of the custom
So
itself
everything is relevant. If the impugned order itself is 1600 pages.
my lord, whenever my lord take kindly give me this hard copy.
Mr. Mukherjee,
I will. Only thing, my lord.
The date will be fixed according to the date on which you serve copy of the
Lordship, I will serve.
petition
I
on
will
it.
serve a copy. Absolutely, Lordship. Only one thing. Lordship is considering a matter which is arising out of the same impugned order. It is being argued by Mr. Obrotosh Mojumdar. Lordship will kindly recall it's a 28 BB of the Customs Act where the show cause notice was issued after a period of 2 years. Lordship has heard that matter, and in another connected matter, Lordship has been pleased to pass an order keeping all the matters together. My Mr. Dotto is carrying that order. I was hoping a similar order can be passed here, Lordship, because we are also from the same impugned order, my lords.
No, this is another matter.
It's another matter.
Yes, sir. Mr. Kundalia.
And in the meantime, I will serve a copy on Mr. Kundalia. This is affidavit directions are passed.
But he should have a copy first.
I will absolutely give a copy to Mr.
Give him a
Kundalia.
copy, then in that case, we'll pass this order once he goes through the papers.
Absolutely.
Without him having a copy.
No, absolutely. I wanted to point this out before Mr. Kundalia troubles himself with the papers. Same order has been passed. Actually, may I just assist your lordship? Lordship will recall there are a bunch of around 100 odd people who are affected by this impugned order, or maybe 50. So all of them have filed separate writ petitions, my lords, and my lord has been pleased to keep that as a lead matter and pass similar orders in all the rest.
Mr. Kundalia, if you can get hold of the, I mean, if you are served with the writ petition and then you can come up, I'll pass this order.
My lord, I'll have to just see and.
Mr. Mukherjee, when can you serve so that I'll keep it on that day, on next to which on which you serve?
Mr. Dotto is there. Mr. Dotto, lordship can keep it.
We'll make a service upon Mr.
He'll serve by
upon Tuesday.
Next Tuesday, Devji.
Lordship, Tuesday and Wednesday I may not be in town. Lordship can keep it any other day, subject to lordship's kind convenience.
Thursday then.
Thursday, and I'll be so grateful,
19th.
my lords. I'll be so grateful, my lords.
19th. Mr. Kundalia, learned senior advocate appearing for the petitioner, submits that a copy of the writ petition has still not been served upon him. A physical copy of the writ petition has still not been served upon him. Full stop. Mr. Mukherjee, learned advocate appearing for the petitioner, submits that a copy would be made over to the learned advocate on record of Mr. Kundalia by tomorrow. By
Yes.
tomorrow,
My lord, if the direction, we can serve it upon Mr. Kundalia's office directly.
Mr. Michael, stop. List this matter on February 19th, 2026. February 19, 2026.
I'm so grateful.
My lord, if the affidavit of service can be taken.
Affidavit of service filed today be taken. Any. Yes, next.
Lordship, I am appearing in the 10, it's the same arising from the same impugned order, Your Lordship. We have physically served them a copy to before the customs.
For the customs, my lord. My lord, we have not received instruction. Kindly adjourn for 2 weeks.
We have physically served them the copy, Your Lordship.
She doesn't have instruction.
Lordship, kindly keep
For 1 week, I'll adjourn.
2 weeks.
2 weeks. 1 week, 1 week. Take instructions within 1 week.
Your Lordship, may I hand over the affidavit of service?
Please give. Ms. Sinha, take it within 1 week. Ms. Sinha, learned advocate appearing for the respondent customs.
Your Lordship, I appear in the same vein if my matter may be brought to parity with the other issues.
I am waiting for the respondent, my lord. My lord, here they have pleaded 28 BB, must violation of master circular, that 3 opportunity, but I could not find out whether they have asked for any cross-examination neither in the grounds of appeal nor in the averment. So
There is a point of cross-examination that
But
you
they have
may.
taken, my lord.
Cross-examination before the adjudicating authority you had sought for?
Yes, I was cross-examined before the adjudicating authority.
No, not you were cross-examined. Whether you had sought for cross-examination of the
Yes, there is a
witnesses who were
point.
cited
Yes,
against you.
yes, there is a point. But otherwise, largely the matters are similar. Now, if the argument is here that the entire proceedings cannot be tenable, then first that may be decided, because I'm not distinguishing my point as of now. I have served the.
He is submitting as to whether the same order can be passed.
Yes, it is. It may be passed. Yes.
No, if you have not taken the point of cross-examination before the adjudicating authority, that part will not be there in the order. That is what he says.
Yes, we are on parity with the other cases as well.
He says you haven't taken. That is what he says.
Your
Show
Lord-
him that you have taken that point, or show me that you have taken.
Your Lordship, is the accusation here that we have not done what the other persons have done?
Yes, that is his contention. He just now said that you have not pleaded.
But then this has been served to him. This is the first time he's raised this contention.
We are not understanding the question. His point is that you have not raised this point of you not being allowed the opportunity to cross-examine the witnesses that I have relied on. Where is that point in your writ petition? Which paragraph, which ground?
Your Lordship may give me some time for this.
Yes. Lieutenant, heard Mr. Heard learned advocate appearing for the petitioner. Full stop. List this matter for further consideration on. That will do. Learned advocates appearing for the respective parties.
Grateful, man.
May the affidavit be
List
served?
affidavit of service filed today be taken on record of list this matter for further consideration on.
No, no, he is asking for item 8 to be also listed next week when my lord will fix this matter.
Which one? 8?
8. The Saruk Khan. Subject.
Very well. On 19. Oh, 8 number to 19 e kori.
Grateful, man.
19.
Full lordship.
সবটা 19 8 এর কোনো অর্ডার দিন ওটা 19 এ ওরা করে দিন কি দেখি কি ম্যাটার None appears for the petitioner. No accommodation is prayed for. List this matter in the monthly list of March 2026.
I've got received instruction as yes, Your Lordship.
Yes, because some other matters should get precedence now because these keep on coming. Next.
I'm for the petitioner.
Hari Kunta.
My lord, there are 2 years involved in this. This is a matter, GST matter, my lord. My lord, in this case, the order in original was passed, and the SSC couldn't make compliance, and later it couldn't fight.
Who is opposing you?
I am there, Your Lordship, in this
You are
matter for
there?
the state. For the state, I am there. Lordship.
My lord, what has happened? The orders were passed, and the SSC couldn't file appeal, my lord, because what happened that he was dependent upon his consultant, the chartered accountant, and the chartered accountant was suffering from various diseases. My lord, he's a
How
kidney.
many days delay is there?
My lord, delay is around of 700 days in the first year, my lord.
April
Delay is there, my lord.
2024, and he has filed on September 2020.
My lord, I was totally dependent upon I have enclosed his medical reports, my lord.
Let them file their affidavits.
Lordship,
File your affidavit.
Lordship, because in the matter, their main problem is that they have not approached the appellate authority.
My lord,
because of the delay.
I have not approached the appellate
They
authorities,
are
my
not
lord,
able
but
to, they are coming from adjudicate.
Appellate authority have not approached.
my lord, I have not approached, my lord. I have come, but we came to know about the orders.
They are
got a
challenging the
communication
adjudication
from the consultant only in the month of August, my lord.
That is
In
the
fact,
only contention, Lordship. So
my
that's
lord,
why.
I'm making humble prayer. Otherwise, they will let remedy less, my lord. Ultimately, they should get some remedy, my lord.
Appellate authority
Well,
Filer of opposition, no interim order.
No interim
Filer
order. Kindly give us time.
No interim order, very difficult. In this case,
Adjudication.
this writ petition Start,
There's a note.
even if you have finished, it will take 1 hour. That I know.
Yeah, this-
With so many people there, that I have understood. So,
My lord, Mr. Banerjee was here, like entirety of last week, Lordship.
no,
he
no,
was
it's
here.
not his problem. I
Ah, yeah,
understand.
Lordship will only.
Even Mr. Tiwari is also
Lordship,
not there.
Lordship.
3 p.m. anytime, my lord. If any day, one day, I think
I'll
that's the
do one
last thing.
I'll indicate a time.
Yes.
After 3:30, so that some
Yeah.
motion matters can make headway. Every
yes.
day, if I take up big, because as luck would have it, every day we were having
my
big
lord.
matters at the
Yeah.
beginning.
Yeah,
So the
3:30.
entire bold was held.
Yes. Well,
Ajke to I am picking it not today.
Yes, my
I'll
lord.
think over it. I'll
Yes.
indicate a
My
date
lord,
from tomorrow.
my lord, I've been sent Lordship certain dates, Lordship, and Mr. Banerjee, it may be inconvenient. May I just indicate any Lordship may indicate a day and then Lordship fixes the time as per my Lord's convenience. My lord, will my Lord be pleased to do?
No, it is running in the list. It's running in the list. Every day it will
Lordship,
be at least
Lordship.
after 10 matters.
Lordship.
I'll indicate a time that it will be either after 10 matters or after this time, whichever is earlier.
Yes, ma'am.
Lordship.
If it
But
reaches
any
that
day-
time earlier, then irrespective of
Lord.
whether I have completed 10
I
matters.
appreciate Lordship.
And
My lord,
this
any day-
time now, my lord, may fix 10 minutes and all. I think it will be.
We
over
won't take
because-
long,
yes,
Lordship.
10
Mr.
minutes.
Tiwari is also there.
5 minutes, 10 minutes. I won't take more than 5 minutes. Finish. Your 5.
I'll take maximum 5.
Maximum, and he will take 10 minutes.
Only one clarification I will give regarding
Yes.
that this multi-origin clarification.
Multi-origin.
Yeah, 10
That
minutes
one
or 10 all. We will.
So you give a date. You suggest a date so that I'll take it off the list and keep it on that day. Tell me a date. All three of you agree to a date so that I can.
Any day convenient to them.
19th as far as we are.
As per convenient of the
Any no problem. Any convenient date. Tomorrow, maybe tomorrow, my lord. It's okay. Tomorrow.
No, tomorrow, day after, I have those Bombay matters.
My lord, as
18 তারিখ কিছু আছে? কোনটা? হ্যাঁ, তো এটা 3:30 পরে ফিক্স করব। মানে I'll fix it around 3:30 or maybe
Yes,
quarter to
yes.
4, so that some motions also
Yes,
are taken out.
motions will be over, then
Yes. So we'll fix it on 18th.
my lord.
develop.
Not passing any order on 18th. It will be understood. It will be indicated in the list.
Develop.
Grateful, sir. Grateful.
ওটাই ঠিক আছে। 3:45 বা 3:30 এরকম কিছু একটা।
This thing is understood. 10 minutes, 10 days.
that you sort out.
Let it be understandable by Mr. Mehta.
Yes, next.
We'll ensure that he doesn't. He remains.
Yes.
15, Nand Kishore Shah.
I am for the petitioner, my lord.
Yes.
This matter, the gold was sold off. The adjudication order was passed. They were refunded this money. Now they have come up with this conclusion that they were not refunded of 1 gram, 1.17 gram money. So, my lord, kindly see, my lord. Page 134, my lord. It starts from page
134.
134. It starts from page 131.
134 starts from page 131. Yes.
My lord. Discussions and findings at 133, my lord. And the last order portion, my lord, 134, page 134. In view of the discussions made in the foregoing paragraphs, I order the following. The amount sale proceeds of the seized goods to the tune of rupees 47,55,230 rupees is to be refunded to the applicant Sri Nand Kishore Shah, Swastika Project, Ganpat Bagla Road, Kolkata, this in terms of section 150 of the Customs Act 1960. So they have received the refund, my lord, in the year 2025. Now they are before, my lord, that they have not
Ms.
received
Mukherjee,
it.
please,
My lord, this
133, where did you read?
134, madam.
134, last order part.
One three four, which portion?
The
So
last
last
portion,
one,
the
that-
order in
Discussions made.
Yes, my lord, order.
Yes.
So it reflects that this sale proceeds have been given to them in favor of the applicant. They have
Yes.
received the sale proceeds, my lord. It's not pending, it's not due. It is that allegation they have not made.
Yes, Mr. Chaudhary, what is?
My lord, may I briefly just recollect your lordship? Refresh.
Also, my lord, the weight at the very instant page, my lord, the weight, nothing was kept.
996.80.
Yes, my lord.
820.
So it was not hidden, my lord. That is one aspect, my lord. So they
Mr. Chaudhary, 996.820 is the weight.
Is the weight they have taken into account for the refund.
Right.
Now, my lord, with this, lordship will kindly take page 7, my lord.
Page 7.
Yes, my lord. No, page 30.
30.
Page 30, 30. This is the Caesar list, Caesar memo.
Page 30.
Annexure P1, my lord, this is the Caesar memo.
Yes.
My lord, kindly see serial number 8, second column quantity.
Yes.
6 piece, total weight 997.99 grams.
Yes.
So, my lord, admittedly, according to my learned friend's submission, my lord, I have received less amount of gold.
I'll come to that. Yes.
I will, my lord. Now, the case that is made out here, my lord, is, lordship, I have, on the last occasion, my lord, this matter came for consideration before the first appellate authority, then to the second appeal. Ultimately, the tribunal ordered for release of the gold. In the first round of litigation, my lord, before this honorable court, my lord, this honorable court has directed for implementation of the order of the honorable high court, learned tribunal. Now, that order is at page 126, my lord.
126.
126.
Yes.
My lord will kindly take page 127. Learned counsel for the respondent authorities submits that the subject says that final order in respect of the order in appeal such and such, which has arisen out of order in original dated such and such, has been accepted by the competent authority on 18/8/2024. Vide e-file number such and such. The written instruction filed by the respondent authorities are taken on record. Heard the learned counsel for the parties. The respondent number 3 in the instant application is requested to comply with the order dated 15 July 2024 passed by the learned tribunal within 1 month from date. My lord will now kindly takes up the order passed by the tribunal. My lord, it's at page 112. It starts at page 112.
The relevant portion is quoted in the order of the honorable single judge that you just now placed.
Yes. Yes. And that portion, my lord, will find at page 122.
Does the order of the sestat also refer to any weight? No.
No, the order of the sestat, my lord, will kindly.
No, it doesn't. I have seen it.
No, it does. No, it doesn't.
It doesn't.
But the Caesar memo, in fact, refers to the date, and based on that Caesar memo, the case was initiated. So cause notice was issued, adjudicated. Arising out from the same.
You had argued before the sestat also.
Yes.
So you know about the quantity of the gold. Ms. Mukherjee did not appear.
No.
She is not aware.
No.
So.
No, my lord. Should not have been. But my lord,
let him finish. I'll come back.
The issue now centers is, my lord, the authority while passing this impugned order, which my learned friend just now referred, my lord, exercising powers under 150. My lord, 150 is a situation where disposal is not objected. My lord, I am in appeal and I objected to the disposal. My lord, my legal entitlement to the entirety of the gold gets accrues with the date with the on the date on which the tribunal passes the order entitling me for the return of the gold. Now, what date they are considering for the refund is very important, and when I am entitled to such refund is the factor to be considered by your lordship. Now, my lord, kindly comes to page 133.
133,
The last para, 3.4.
3.4.
The Deputy Commissioner of Customs S&D CCP, by their letter dated such and such, informed that the quantity of gold in respect of the mentioned seizure case number weighing at 996.820 grams has been already handed over to SPMCIL Vide HOGS note number such and such dated in compliance with the board direction number 27 by 2021 customs dated 3/12/2021. My lord, the date they are considering for relevant for refund of the amount is, my lord, it reflected in this paragraph only. And since the gold is already disposed of by way of handing over to SPIMCL, the refund of the value of the gold is processed as per instruction number such and such dated such and such. In this regard, a meeting of the Joint Pricing Committee was held on 14/1/25 under the chairmanship of the Joint Commissioner of Customs Preventive for fixing of a fair price gold prevailing on 13/1/2022. Well, 13/1/2022, my litigation was not over. I was still in appeal. I made a pre-deposit for filing the appeal. Now, my lord, the statutory provision says, as and when I make the pre-deposit, recovery is automatically stayed. So, my lord, any action contemplated into the seizure case is also stayed. They cannot dispose it in a way they desire. 150, they issued me a notice. I objected. You cannot dispose because my appeal is pending. My lord, kindly seize that. It's at page, my lord, 110. My lord, let me come to page 108 first.
110.
108.
108.
108.
Yes.
This is the notice under section 150 of the Customs Act 1952. Well, here the Superintendent of Customs Preventive refers to the seizure case, and this is informs that this is for your information that the 6 gold weighing at 997.99 grams. Well, kindly take note of this remark passed by made by the learned superintendent in the 150 notice itself.
Yes.
Now, what he does, he says, which were seized under seizure case number such and such is being disposed of by order of competent authority as per the procedure of disposal, pre-trial disposal of goods. Well, this is dated 28/12/2021. Kindly turns over page 110.
Yes, page 110.
This is my response to the 150 notice. The last line is important. Therefore, the undersigned humbly praise your kindself to hold back the goods from being disposed, sold, or distracted.
Yes.
So, my lord, the disposal of the goods with this objection is arbitrary to the provision itself. Now, my lord, while passing the order, he has taken into account, kindly comes to page 134. He has taken into account the date as 13/1/2022. He disposes of my goods even with my objection, without even bothering to hold back to the goods when even intimated that they are under the preparation of an appeal, they are contemplating an appeal, statutory appeal that is envisaged under the Act. And my lord, the learned tribunal while has passed the order in 15/7/2024. My lord will kindly take page 112. This is the order of tribunal. 15/7/2024. My entitlement over the goods arises here on this date, and it gets accrued on this date. So, my lord, even while granting me the refund of the sale proceeds of the goods, the date are very important because prices increase on the dates. It's the proceed.
But Mr. Chaudhary, in your writ petition, you have only prayed for refund of the differential sum.
Differential sum which is accrued because of the passing of the order.
Right. You are no longer challenging the sale per se.
I am not challenging the sale per se, but the disposal was contested. My lord, they should not have.
Right, that is there. But
Yes.
At that point of time, since the sale was not contested, it is not even contested today in the sense that there is no challenge thrown to the sale.
My lord, since the goods have been disposed of, my lord, my prayer is twofold, my lord. From the seizure memo itself and from
the differential amount you want, this is one, you want refund of the pre-deposit. That is what you are
refund of the pre-deposit, refund of the differential amount
With
between the date that is when the goods have been sold and when I am actually entitled to the return of the goods.
You want refund of the or payment rather. There is
Yes.
no question of refund. Balance. I mean, some equivalent to balance 1.17 grams of gold.
That is the differential portion which has not been admittedly given to me.
Yes.
And the amount that has been refunded to me as the sale proceeds, that sale proceeds cannot take into the date as 13/1/2022 as a whimsical date by the authority
Where
concerned.
is that prayer?
My lord, prayer A, my lord.
Prayer A. You say implementation of the
yes, my lord. Prayer A, my lord, implementation of the order of the learned tribunal itself entitles me for the execution of this order of seizure and returning me to the goods. My lord, if the goods are not given to me, then I am entitled to the value of the goods. My lord, I'll cite
the order of the tribunal is flouted, Mr. Chaudhary. What is the recourse to you? Only writ court.
My lord, order of the
tribunal is not adhered to, not followed, or is flouted.
My lord.
The recourse is only writ court. Tribunal is not there to
My lord,
implement its own orders.
My lord, the tribunal is there. My lord, the order has the tribunal is there. Definitely, your lordship can direct me to approach the learned tribunal for implementation of this order.
That will
But
be
my lord,
better.
the situation will remain the same. Situation
So
will remain the same.
better the tribunal decides it because these intricacies ultimately.
My lord, I'll cite two decisions. My lord, kindly allow me to come back on the
Yes,
next day.
definitely. I'm not stopping you or I'm not
Lordship.
rushing you.
Lordship.
I have to open my mind to you so
Very
that
well.
you can meet it.
Very
right?
well. Very well.
I'll not decide it with a closed mind and then
Very
something
well,
else
definitely,
I'll put it in the order which you did not have occasion to deal with. I won't do that.
Absolutely.
That is why I am a talkative person. I keep on talking so that you all can respond.
Very well, my lord. I'll answer to your lordship's query, my lord.
Yes.
With that respect, my lord, my lord, at the time of seizure, my lord, in case of gold, my lord knows the scale matters because there is always a negligible part which is deducted, my lord, and it varies in each and every case of measurement. It varies from scale to scale. My lord, kindly consider this is a 997 or 996.
When can we meet next?
My lord, Monday, my lord has fixed.
Which one?
My other matters, so I'll be there on Monday.
Very well. I'll come back on Monday, my lord.
Monday next, my lord. No, Monday, no. 18th, my lord has fixed my matters.
18th have fixed a lot of matters. We can have it on 16th, 17th.
16th, my lord? 16th.
16th, Mr. Chaudhary.
My lord.
Heard Mr. Chaudhary, learned advocate, appearing for the petitioner, and Ms. Mukherjee, learned advocate, appearing for the respondent customs authorities. Full stop. List this matter for further consideration on February 16, 2026. ये ले लीजिए। Thank you.